at the time of the petitioner who is the engineer and contractor, his bid was rejected under clause 4A. When you were this they have filed. Yes, they have said now.
Calculation.
Yes, they have said that I have uploaded a petitioner has suppressed a.
I was not aware. My brother is more
I am giving
with the system.
No, I have given the lordship. Sir, they have during course of hearing, state opposite party submitted instruction that the present petitioner suppressed a figure which is at page 223 and 204. Both are contrary to each other, Miller. I sought time to take instruction in the matter. Miller, I just Miller 5 pages, 5 paragraphs, Lordship. They have completely this document are uploaded. Kindly, Miller, I just submitted a rapid
now he has filed an affidavit, Miller. Copy is given to me just now, Miller.
No.
The lordship, the complete, this is my humble submission for lordship. 203, 204 are separate was, and 223, what my friend has relied in the state, is not conformity with the tender notice. That is in addition to 203, Miller. And 20, Miller, your lordship kindly paragraph 1, 5, Miller, I am permitted, please. It will be clarified.
Is there any condition in the tender matter the similar?
Yes. That is a formula.
Yes, this Miller,
This work does not fall within the scope of that tender.
yes, Miller, yes.
That's why you have not
Yes.
disclosed.
No, I have disclosed. They are saying figure. The condition provides there is a 4A notes. This will be calculated existing commitment work in which the countersigned by the document whose bidder is self-assessment cannot be signed calculated. The document which is uploaded and the from whom he executed the allotted the work, the must have been countersigned by the superintending engineer. So in conformity with the countersigned the document that is 203 and 204. My state has relied in page 223 and the evaluation made on 223, which is the self-assessment of the petitioner. It cannot be Millard assessed. For this reason, Millard, both the documents are uploaded. It is in the tender file. There is cannot be said there is a suppression of figure. Your lordship, can you have my short affidavit?
No. Suppose there is no suppression, but what they have said that I think my brother has the experience of that. That every work when any contractor is doing, there is a portal.
Yes.
In the portal, it is all uploaded.
Yes.
And this portal can be accessed by the authority. Suppose if you have suppressed certain facts, where the portal shows that you have been awarded work and you are doing this work is such and such. Then in that event, the authorities can definitely take into consideration what's out there. Probably in this case, that has happened.
No, there is not. The instruction.
That is what is the word.
Have you taken the wireless data? You have taken from wireless data that he has suppressed this figure which is available in the wireless.
That part I have taken instruction.
Take instructions.
Yes.
Yesterday, the matter was adjourned he wanted an inquiry over the work in serial number 127. I do not know, very cryptic, rare.
May I
That's what he really wanted.
get the,
And there are many typographical errors in the prayer itself.
may I get the
Which you have
representation?
Not noticed, not corrected.
Let's see the representation at annexure 2 minute. As per my instruction, no such representation is given to the authority, which is against the.
What he has an issue is that, though you have issued work order. Actually, work was not done, but it is said. That you are.
Yes, please.
That is the allegation.
Yes.
His entire work.
So whatever, whether representation or not representation, the repetition is basically this issue.
I will take
You have to
instruction.
respond to it.
Yes.
File an affidavit. And matter to appear 3 weeks. So,
Item number 3.
May I please your lordship. Your lordship, the prayer of the petitioners for a direction to the opposite parties cancel the appointment of retail outlet dealership of petrol pump, which has been allowed to be built, your lordship, violating the safety measures that have been prescribed by the Petroleum and Explosive Safety Organization.
how it becomes a public interest.
Your lordship, an association, your lordship.
Madam, we did not get the point which I asked.
The public.
How it involves a public.
Because your lordship, in fact, it was filed as a writ petition, your
I
lordship.
understand, but
However, the safety measure concerns the public at large, your lordship, since it is regarding the space to be maintained between.
I think this is like, what is the concept of a public interest litigation? I am still at loss. That every litigations which is personal, which is only in relation to a particular act, becomes a public interest litigation, which infringes either the fundamental right of an individual. In a public interest litigation, the issue must be of such a larger magnitude that the authorities are required or a mandamus is issued to adhere uniformly everywhere, not in relation to one act. If you are challenging a particular act of an authority in relation to a specified thing, it becomes a public interest litigation, also written in the nature of certiorari, washing off the act of the authorities, being the violative of the statutory norms of the province. Everything becomes a public interest.
Your Lordship, it was in fact
My
filed.
property, not my property, the nearby property belonging to X is he can approach the single bench. Public interest litigation. A busybody, the vagabond comes. It becomes more a publicity interest litigation than a public interest.
In fact, the petitioner had approached the single bench, Your Lordship.
I have seen the order, that's why I'm reacting.
Perhaps, perhaps 13. This is some perception we have 22.
Yes, Your Lordship. That was also one of the repercussion of the illegal act, Your Lordship.
Has they been uniformly not following this
No, Your Lordship, that is not the case.
everywhere, or it is only in relation to one Anganwadi center?
It's related to one petroleum dealer, Your Lordship. However, if it is allowed, then the cascading effect will affect the public at large, Your Lordship.
And
Because-
also inside the city,
Yes, Your Lordship.
you have not.
Anyhow, we are not making any comment on it. What is your there? What is the problem? They are not adhering to a safety norm.
Yes, and they have
And
granted
they're
NOC.
operating in a congested locality.
Yes, sir. Just 30 meters away from the petrol pump, Your Lordship, is an Anganwadi school, which is not only in violation of the safety norms, Your Lordship, but also NOC has been granted by the district collector towards the location and the construction has started, Your Lordship.
There is a new petrol retail outlet.
Yes, sir.
But
Let notice be served on me, my lord. I'm appealing for 1 and 2, my lord.
who are you? One and two?
I'm for Indian Oil Corporation.
No, NOC is granted by you.
Yeah, LOC is being granted by the
Or
district. office.
sorry, I think the license is granted by you.
Yes, ma'am.
How?
We have added to the norms, my lord.
What adheres to the norms that if there is a nearby school,
No, it is beyond the NH, the norms which my learned friend is referring to, Annex 2, page 12.
yes, yes,
Perhaps 3 of yours circular.
what?
And page 12, my lord, Annex 2. That
Yes,
is the annexer, my lord.
correct.
There is a rider within 30 meters, it should not be there. My
It should
Anganwadi
be
is,
30 to 50 media.
it is beyond 50,
It
man.
it is beyond 50.
Yes, madam. As per my instruction, it is beyond 50. If your lordship wants,
What
I
is
can
your
put it on affidavit.
perception about 30 meters?
I'll put it on
Your Lordship,
affidavit
it
if
is
your lordship wants.
adjacent to the
I am
petrol.
just asking you, madam, have you got any material that it is within 30 meters radius?
Your Lordship,
There must be.
as per the
Have you measured it? It's an aerial distance or it is a road distance? What?
Your Lordship, as per the pictures, Your Lordship, picture has
Can
been
we-
annexed.
Can you measure the length and breadth of this report hall?
Your Lordship,
By your eyes, can you measure it?
not been considered or nobody, Your Lordship, it is.
Why you will burden an authority without any evidence to come? Once they have granted a license, then the presumption is that they have followed the rules. Unless you demonstrate that this particular action is violative of this. Then you have to produce any strong, mere moral evidence. That is what is the entire country is grappling. That somebody without any piece of evidence, without anything, just make a representation. And then the authorities will have to leave other important work, have to concentrate on disposing of the.
Your Lordship, it is on affidavit that as per my instruction, Your Lordship, that they have.
What is the material which you say that it is?
Lordship, they've
You
annexed.
file your affidavit, say beyond 50, we have to
Yes.
then oath versus oath.
Before that,
One
I
has to be.
like to bring to your lordship notice. A similar matter, single bench has looked into my. Guidelines has been taken note, my lord.
Circular which is,
Yes, my lord, it's into 7/1/2020, my lord.
for circular that is.
Produce, we did not produce a piece of evidence.
Your Lordship, the evidence, Your Lordship, is the photograph, Your Lordship, saying that
Sir,
it is
can
completely.
a photograph, have you used that particular technology where, while taking a photograph, the measurement can also be shown? Have you taken that particular technology?
Your Lordship, I can take instruction if any map,
I
this
just
was used.
will have
Your
to
Lordship.
say, is the radius it calls, it may be a 30 to 50 meters
Distance.
of aerial radius. It may be by road, it is at the distance. What is this? What radius has to be taken into account?
Your Lordship, they're adjacent to the distance between both the schools and the petrol pump has to be. I can take
How much?
instruction.
30 meters, how much? What do you think? What is the distance? Calculate in the feet. How much? File your affidavit.
Yes, ma'am.
No
Let us-
issue of notice. When you have appeared, we waive the notice, give a copy.
Yes, ma'am.
The respond, I do not oppose it.
My lord, the Lokaयुक्त has not been functioning for last 1 year. There is no chairperson or member.
Which one?
The Lokaयुक्त Odisha, the chairperson and members. This is the act I am providing, madam.
The local,
Lokaयुक्त Odisha.
There is a
consisting.
chairperson of the Lokayuk.
Yes.
Lokayuk itself is a post.
Yes, no, Lokayukta.
And there is a members assisting Lokayuk.
Yes, my lord, I am providing the act.
Oh, this is here, this act.
Yes, but kindly section 3, section 3, my lord, page 4. Here the Lokayukta is an institution and there are chairperson and members, judicial members.
So what are you doing? Why are you Lokayuk?
The last member. They all demitted the office in August.
In August.
August 2024.
Nearly more than 1 year.
More than that.
And they did so.
My lord, kindly see section 6 and at page 6. The governor shall take or pose to be taken all necessary steps for the appointment of a new chairperson
I'll take it.
before 3 months. Yes, my lord. Before the expiry of the term.
Everything is there.
Yes, my lord.
I understand.
I'll take instructions.
5-year academic.
Will-
Yes, we have the ATA reports and we have also presented some representation.
There is an admission that he has himself says a letters in the month of August 2024. And no appointments have been made. Whether steps have been taken or not taken, he will take an responsibility. But the reality is that the appointment has not come.
Yes.
That's all. Yes. One affidavit will do.
One.
This also.
One.
The tag with this one.
Yes. Item number 5.
Yes, sir.
Item 5.
S.K. Mohanty, where is he? On his prayer, the matter was adjourned. It was directed to be listed along with the committed matters.
It is, yes. Both the matters.
And then who is appearing, where is Mr. Kipaki? No, he is appearing in both the matters.
Yes.
None appears in support of the repetition, let the repetition be released after revision.
Yes.
I mean.
My lord, seeking permission to appear online, my lord. My lord, I will draw lord's attention, my lord. This dispute relates to, my lord, one of the, my lord, the agreements which is on page.
Where is clause 24.1?
My lord, it is on page 132.
132.
My lord, Article 24. My lord, 24.1.1. My submission is that, my lord, it is not a mere, my lord, useless formality, my lord. This is something which is, my lord, coming with the word shall. And my lord, we have to continue, my lord, throughout the period, my lord, I have to execute the work. So conciliation must be something.
Simple use of the word shall does not make
It mandatory. It is
Well,
interchangeable with may, and
I
may also be regarded as shall.
I bowed
We
down,
have
my
to
lord.
consider, we have to
Mine.
consider what is the.
I bowed down, my lord. I'll read it out with permission, my lord. 24.1.1. My lord, any dispute, difference, or controversy of whatever nature, or howsoever arising under, or out of, or in relation to this agreement, including its interpretation between the parties and so notified in writing by either party to the other party, shall in the first instance be attempted to be resolved amicably within 30 days. The parties agreed to use their best efforts for resolving all disputes arising out under in relation to this agreement promptly, equitably, and in good faith, and further agree to provide each other with reasonable access during normal business hours to all non-privileged records, information, and data pertaining to any dispute. My lord, 24.2 also, my lord. 24.1.3 also, my lord, with permission. During pendency of the dispute requiring resolution, the mine operator shall not stop the work and should continue to execute the agreed work unless OMC specifically requests the mine operator to stop all or any of the work. So, my lord, litigation. In the event in the dispute cannot be settled amicably between the parties, the aggrieved party may approach the court. So my humble submission, my lord, is that at least there should have been some attempt. And my lord, we are continuing with the relationship. It is not that the contract is terminated and I'm into arbitration. And
I am in fix whether any mandamus can be issued in this nature.
my lord, to support your lordship.
I am in fix. Please tell me, show me that the
Yes.
repetition of such nature is maintainable.
My lord, then that
It is
eventually.
what it says that the point, this connotes that they will just make an attempt to resolve the dispute. Attempted, to be attempted, the word is be
Shall-
attempted to resolve. So that is what is the option. It is what is the conduct which is important.
My lord,
They should attempt, make an
yes.
attempt to resolve. If not resolved, then court.
even that
It's like
part
a
is missing.
pre-litigation mediation concept.
My lord, even that
Some
part is
extent.
missing. Even they are not attempting. And my lord, may I-
Anyhow, so can we go? If suppose if somebody is not responding, that implies that he is not agreeing to resolve or there is a
my lord,
I
can
said tacit denial of the amicable resolution.
my lord, in that eventuality, to assist your lordship, may I just show 2-3 judgments, my lord, as to why this shall be.
Please quote us. That's why I say I am in fix. Show me the
My
law.
lord, please. My lord,
Please.
I will start.
Clear
with-
my conscience.
My lord, we are learning from your lordship, my lord.
No,
In
no,
fact,
no, no, it's not.
My lord, first is, my lord, in Sanjay Iron, my colleague is there, my lord. He will just.
Yes, give it to me.
Sanjay Iron and Steel versus Steel Authority of India.
Yes, let us see. He's grappling with the papers.
Uh,
So let him forward.
Mr. Suvendu, forward all judgments to your lordship. We can just sort it. My lord, in the first one, Steel Authority.
Yes.
And last, I will come, my lord, on the mandamus because Punjab and Haryana High Court has issued mandamus. So just to assist your lordship, my lord. This one, my lord, I will draw lord's attention straight away in para 19.
This is a single bench decision which you are referring to us. And that was in relation to an arbitration matter. Sir, the arbitration matter,
Then, my lord,
11.6 mandates certain acts to be done. And if the statute provides a thing to be done in a particular manner, it has to be done in such manner and not otherwise.
yes, my lord.
We are reminded of this Nazir Ahmed's judgment.
My lord, I vote.
Yeah,
I
yeah,
vote.
36 Privy
My-
Council, if
my
I'm
lord,
not wrong.
my
So
lord.
this is on this principles, this is what has been decided.
My lord.
But it is not a statutory document. It is what are the contractual obligations. If a party resile therefrom, then you have a remedy before the court that whether he can resile or he cannot resile.
My lord, in fact, I can, my lord, this is part 2 can certainly be looked into, my lord. So,
That is what I'm saying. That the writ in the nature of a mandamus can
my lord, in fact, the
contractual matter.
my lord, the one writ petition of Punjab and Haryana High Court where
Please
the
show
mandate,
us. We have
my lord,
not come across.
one pager, my lord, by division
In
bench.
an arbitration act is a special act. I think the self-contained court.
Well, that was in respect of a tender matter, so probably that would
Whatever,
assist your
I do
lordship.
not know.
I will,
But
my lord,
I have some.
my lord, one page that is Goran Gate Cooperative Society versus State of Punjab.
Just 1 minute. Let us see. Sir, how can you rely upon this document? This is really on concession. there the authorities have given an undertaking to the court that in the event they apply for amicable resolution, the authority will decide within a particular time. And on that basis, the court has said that you make an application and then you decide within a time. How it applies to this principle? I am stuck up on a point whether the writ of mandamus can be issued upon the authority to adhere or implement or follow one of the clauses of the contract. If there is a violation of any terms and conditions of a contract, you know the specific fact comes
then-
into play, specific performance you can sort for mandamus. The writ jurisdiction.
My lord, then may I request your lordship just 1 week time? I think, my lord can issue, my lord. I think.
Let us see, please show us.
Please,
show us
I'll do
no
that.
difficulty. I have already said this is the confusion, or I would say something is going in our mind.
My lord, I bow down, my lord. Whatever assistance, my lord, I can.
Dispel it, no difficulty.
I bow down, my lord.
When? 1 week?
1 week, my lord.
1 week.
Obliged, Your Lordship.
Deeply obliged, my lord.
Item 7.
The petition has been. So petitioner has granted a query list for cleaning on 13/11/2023 for a period of 5 years.
Have you find the amended possibility?
Yes, I have filed me. I was operating the source for more than 1.5 years.
Yes.
An original application was filed for the NGT alleging that I am violating the SC conditions as well as I am doing excess mining. So the learned NGT admitted the original application and passed the order on 4/4/2025. That is at page 139, annexure 3. Relevant paragraphs are from page 133, paragraph 9.
133 or 139?
133.
133.
This is part of the order dated 4/4/2025 of the NGT. Paragraph 9 and question. Matter requires consideration. Issue notice to the respondent returnable within 4 weeks. Para 14. Issue notice to the respondent number 11, Deputy Director General.
Whatever, that is the issuance of the notice.
Paragraph 16.
Constructive. Where is the constructive order?
Paragraph 16.
Constitute a committee.
Committee was constituted and matter was posted to 8/7/2025. So next page, my lord, you can see annexure 4 at page 135.
Yes.
Well, on that date, I entered appearance before the land NGT. And prior to this, the committee submitted the report. No notice was ever issued to the lessee to appear before the committee for spot inspection. Well, on that date, without giving me a copy of the joint inquiry report, without providing me an opportunity to file the objection to the committee report, now, my lord, we can see by this order dated 8/7/2025, my lord, we can see page 136. Paragraph 6. Affidavit dated 1/7/2025 has been
Taken
filed.
on record.
No, that was not served to me. Copy was not supplied.
Go before the NGT, then say that the copy has not been served. For that, why do you come to find a writ petition?
No, my lord, we can see what the NGT did.
Records your presence.
My presence in paragraph 12, my lord, we can see. while allowing me to file the counter affidavit, now minority paragraph 12 at next page.
Yeah.
We further direct the state respondent to file the action taken report with regard to the recovery of environmental compensation. So that report of the committee was accepted. And direction was issued to the state authorities to give effect to the committee report. I was not provided any opportunity of hearing. Now, my lord, kindly see, the committee report was sought to me on 37/20/25 under annex.
That is not yet terminated, so you can.
You go
So
there,
nothing remains to be decided in a similar
what
situation.
is it saying? You go before and say that this is what is the compensation is.
No, there on 22nd of last month, 28/8 matter was there for the land NGT. So I prayed, they kindly allow me to file objection. They said no, since we have already directed in paragraph 12.
The approach is something different than what can be done. So simply asking an opportunity to file affidavit will not do, you know what is to be done.
So
Can a jurisdiction be decided on the basis of property being involved in it when a judgment is delivered by another a particular forum which is outside the territorial jurisdiction of the High Court?
in several matters, this honorable court has entertained the.
Don't go by those. When a confusion has come, query is
Territorial jurisdiction.
226, you know. 227, actually 226 will not come. It is under 227.
An authority sort of it.
Tribunal is not an authority.
Quasi judicial authority.
Article 227, where the power of superintendence is exercised by the High Court over all the courts and the tribunal, both.
Tertiary.
What's actually? It's the power of superintendence. 227, 226 is not.
Let me examine on that aspect. So the issue
Because
is
this order is passed by a tribunal whose situs is at Kolkata, that is within the state of West Bengal. Whether the High Court of Orissa can exercise. Yeah. Is because of the territorial jurisdiction. Can we expand territorial limit?
95 Supreme Court.
What Article 226, sub-article 2 was introduced by virtue of an amendment. And the concept of section 20C of the Code of Procedure was ingrained into it. In relation to a cause of action in the territorial jurisdiction. How can it be exercised?
Just to examine on that aspect.
Certain DRT matters must be taken up in that city. Certain DRT matters taken up here, relying on some Supreme Court, some Supreme Court judge.
Don't go by that Kusumingar judgment of the Supreme Court, Alchemist judgment of the Supreme Court. I'm quite aware of those judgments.
So that is why I said 95
I
Supreme
know,
Court first.
I'm quite aware. When you talk about Alchemist, you talk about Kusumingar.
Prior to that, Utpal Banerjee or Utpal Chatterjee.
But I believe that it needs an introspection.
Yes.
Let me examine on that as well.
Yes.
But the issue is,
That is a different. It is the tribunal who has passed this order. Tribunal is situated, exercising its jurisdiction there. In another state.
so, Because my, also the consequential prayer is that I am also challenging the demand.
Sir, that's why I am also conscious of the provision of the Code of Section 16, probably D, where the jurisdiction in relation to immune property, where the property is situated, the jurisdiction of the court will be there. I am conscious, but still in relation to 226 or 227, what to do? Yes, 16D. That's a 46 bill. But clause 2 of Article 226 read 1A. The power conferred by clause 1 to issue directions, orders, or writs to any government, authority, or a person may also be exercised by any high court exercising jurisdiction in relation to territories within which the cause of action wholly or in part arises for exercise of such power, notwithstanding that the seat of such government or authority or residence is not within those terms. That's so as
Sing 1A, 226 1A.
Two 26 1A, capital A.
or 26 1.
A.
1A.
There is no 1A. There is no 1A. Where is 1A? 226 of Article 3A. No.
From the book and company.
What?
So far as Article 1A is concerned,
Where is 1A?
which are available in the website.
Yeah. Those provisions have been omitted much earlier. 27, you are looking at the provision, I do not know. It has been or undergone a very, very significant change in 1977. But
226 2 please.
226 sub, the article, sub-article 2 or clause 2 is a very important one.
That's right.
In exercise of jurisdiction.
I do say.
Show us unnecessarily we should not.
Let
And
me
then
grant-
also 227.
let me grant some adjournment.
Yes, 227 also considers.
Yes.
Whether it is a case of a 226 or 227. Come.
Government of India has published some. no bunch. It is updated till 2024. That petition is available, Hindi and English version simultaneously in the web portal. Constitution of India. Bharat Sarkar. So. No, that is not there. 26, 1, then 2.
And then three, A, B, C, A, B.
Small a, small b, then 4.
Yes, sir, John,
Yes, sir.
2 weeks. Consider.
Item number 9.
My senior election court number 7.
Who is the senior?
Senior advocate Mr. Ashok Mahathir.
Where is he?
Election court number 17.
You are waiting there. Just now.
He has gone to the. They'll come in next week. Yes. That's what happens. Yeah. You come on Monday.
Lordship, pass over my sales. It's up to pass over.
Possible.
Item 10.
For this, for yesterday's matter.
That's what Mr. Project made idea taking up a child.
Where is the problem?
Inconveniently paid. Inconveniently paid.
You are clear.
Yes.
Yes, very clear.
Well, I received the copies. I'm also preparing the count. I will count the course of the day as well.
What was the matter involved?
Lots of the matter was
We put certain.
replacement of train trucks. Replacement, yes, yes, yes.
CT.
On the ground,
Yes.
they said that they wanted to provide me the better vehicles.
Whatever you say, you say that,
For the sake of repairment, they made me application, but that
you
was,
said that their application was something different.
yes. And yesterday also, after getting the file, I inquired, I find out that during the sustenance of the contract, those TTs have been already put in tender to HPCL. When it got selected in HPCL, now that they've hidden that up to till date, till this time also, they've never intimated me, the IOCL, that the tank trucks, which has been,
It is immaterial to you.
lots of.
The only thing is that whether those tanker trucks were taken out or taken off from you, no. They were permitted to be utilized and used for your purposes. Your only concern is that there is no disruption. And
There is no disruption as well.
the uninterrupted supply or transportation.
That's it.
There is no allegation that there was any disruption. If he has gone to your rival company also.
No, it is not about that,
take care of
Lordship.
transport. Don't be jealous. Don't be jealous.
It is not about jealousy, Lordship. It is violation of ITD.
Sorry, we have seen the article is different.
No, Article 5.1 is not.
Sorry, different. You have taken a shelter under a particular article, which does not apply.
Lordship,
You cannot take a further point when your authority has not taken.
Your Lordship, when the misrepresentation has been done.
Just
Lordship,
let us see.
From this
Let us see.
document yesterday. Let's be one, new one. Of the same price.
It's the old and also no.
Higher capacity.
It is of 2021, Lordship.
Higher capacity new ones. Instead of these will be utilized for other. So the participation.
It is not the issue.
Participation in.
But the representation that was made is the tractors are odd in condition, that is not operated.
Sir,
And the
you
second
are
one
not
is-
concerned with this. If they have done anything with the of the particular class,
My lord.
which was already being used and utilized for your purpose. It is a matter between them and that
Absolutely,
particular
sir.
company whether to go with it or not to go with it.
My lord.
Who are you to put a spanner into it?
No, I'm not. But Lordship, clause 5.1
Why?
of the ITD just says.
I fail to understand. The person has approached the authority saying that this two trucks are of very old origin.
That's also wrong, you know, sir.
Of a lesser capacity. I have purchased a very brand new one, which is a PS4 compliant, which is the absolutely good, having a large, more capacity. And then you are saying the rejection.
It is not about rejection also. It is about the NOC that has been granted, no certificate. It was granted on the presumption that the tankers are in bad condition. But the fact is, the
Sorry,
tankers by
we
the
have
time has been
not.
already
He has written that I have already participated in another tender. I want to participate, and therefore I want to use these two tenders in that particular tender.
It has not been said here also.
Sorry, the
I
letter
can read-
was shown by him, handwritten letter.
If I can read out.
Page, please read out.
With due respect, we have two numbers
Page
of
85, page 85.
83. Annex to
Handwritten. I read if I correctly remember. Yes.
With due respect, we have two numbers of tank trucks bearing number so and so have running with you. We want to participate in the same in another tender. If we are selected, then replace the same with new tank trucks.
Is what?
Kindly.
And the no objection was given on that basis.
No, your lordship, may I read it down? Read it down. This same page 82, just previous page. There has been two presentations. The whole issue is the NOC has been taken without misrepresentation. That is the whole issue. That is the reason. And when HPC intimated
There
us,
have to be a model,
employer, your lordship.
contractor. You cannot. When you are given a better, the transportation or a transport vehicle, I think you should be very thankful to him.
Look, that's
And you have said that the new one should be a BS4 compliant.
no, we have not said that. Your lordship, kindly page.
Your clause
What my
says that if you want to replace it, you should replace with the new one having a BS4 compliant.
Your lordship, kindly see page 82, 82. The previous page, what my learned friend is page.
31st July.
No, that is 31st July. Your lordship, kindly.
The very next day.
Your lordship, kindly see the contents.
There is no contradiction.
Yes, lordship. Despite, your lordship, for a moment, may I please read? If my lord so says that I can file the counter is ready with
It's
me.
not that.
Or if your lordship wants to hear it, I
Then
can
we
place.
will permit you, and if we are not satisfied, we know what
Yes, yes.
conditions we can impose. We know also the conditions to be imposed. If, but for any reason, if the tenders are cancelled, that they cannot put those trucks, then we'll see to it.
But see, those two tank trucks, they have already purchased since 27/10/2024. Despite
Whatever is the reason, is there any embargo in your clause or in your statutory document?
Yes.
That one cannot replace?
no, he can replace.
So-
So not with a lordship cannot be.
Where is the condition put in? Show us the clauses. Now I'm critical. Show us the clauses, under what conditions they can put,
Lordship,
and there is an embargo
I'm
that they
just trying
cannot
to
put.
apprise. I'm just trying to apprise the decision process. It is not that I
Please
don't
show
have
us
to
the
do any-
clause, show us the
Yes,
clause, let us see.
clause 5.1. I'm just placing one.
Yes.
I don't kindly appreciate because otherwise I'm not in a.
No, we will be considering with the open mind.
Yes,
And if we find that your action is absolutely contrary to this,
what my learned friend
we
is.
are not concerned. We have the letter
Clause
which
5.
he has written on 1/8/2025.
Lordship.
No
I see.
objection was given, please consider. No objection was given on 1/8/2025. Same day.
NOC has been given, Lordship.
That is
But
what I'm
two
saying.
letters have been issued.
These
Before
no
that, there has been a
objection-
contract, there is an agreement.
Objection does not indicate anything. And only this no objection was in reference to the handwritten letter dated 1/8/2025. He did not take into consideration the earlier letters. He took into consideration handwritten letter of 1/8, where they have
Both the
categorically
letters,
said
Lordship.
that I wanted to run these two trucks, or we wanted to show these two trucks to participate in another tender.
It is never written. Never written, Lordship.
Sir,
I will, but by that time it has been already used.
83. Please come to page
My lord,
83.
my lord.
Don't argue in vacuum.
My lord.
Read loudly for all of us.
Yes, madam.
Please.
With permission. With due respect, we have two numbers of TT bearing so and so have running with you we want to participate in the same
Participate the same,
in another tender.
correct?
If we selected, then replaced the same with new TT, kindly consider request.
Correct.
By
What
this
does
time-
it mean?
By this time, they have participated, they have been selected.
Whatever be the there. Sir,
And
it is a
after that-
matter- it is, and then come to page 84.
Page 82, if you not.
Please come to page 84.
Page 84, yes.
What is the first line of the no objection certificate?
This is in reference with letter dated 1/8/2025.
So that
You
is
have
the
requested
handwritten
for
letter
NOC.
of 1/8.
1/8/2025. You have requested a no objection certificate from IOC for 2 number of tank trucks as following. These trucks are current running under contract with IOC at Paradip Terminal. You have mentioned in your letter that in the event you being successful in the tender, you will give replacement another higher model TT immediately.
Correct. Correct.
In this regard, it is informed that IOC has no objection in participation of these TTs in other tenders.
Correct.
But if I pause for a moment,
What does it mean?
you have mentioned that in your letter that in the event you being successful in the tender, you will give replacement of it. By the time they have already participated, they have offered the TTs. Once they got selected in that, while the sustenance of the contract of this period, that's my only grievance also. And if you also kindly appreciate for a moment, page 82. Before giving the 1/8 letter, 31/7, they have already intimated that my tank trucks are in a bad condition. I have to repair. Consistently, they are making this stand
Sir,
without intimating.
Sir.
That is the reason I have already come before you also.
so sentimental,
No, it is not
so
about
emotional. That one thing that have really shattered your heart, that has really done. Sir, you have to. Only thing is when the subsequent letter is issued to you, and then that letter shows a different ground, and you means your authority did not take into consideration the earlier letter because they thought it correctly that the earlier letter is superseded by a subsequent implied.
If my lord, I can
I
place
think,
the mails,
the
the mails, if I can place your lordship.
law of notice connotes that. If there is a earlier notice, and if there is a subsequent notice of a similar nature,
Lordship.
then the law is that impliedly the earlier notice is being.
My lord.
So this was the letter which you are referring every time, projecting as the more,
Now, my lord,
like
if you must kindly come out to page
like a
87.
invisible or
Subsequent-
invadable, the missile. This was of 31st of July, 1 day before the 1st of August. Subsequently, they said.
Subsequently, again, they say they want for repair, your lordship. That's my error.
Considered and issued no objection.
My only thing is, your lordship, the misrepresentation, continuous misrepresentation.
We have heard you, anything more?
Your lordship, page 87 for a moment. That is the subsequent letter.
Real?
Yes.
You
Page
have
87.
withdrawn?
Page 87, the mail dated 21 August 2025.
Yes.
There also they have said the TTs has been allowed for maintenance work. However, please note that degassing of the TT must be done before conducting any hot work. Strict adherence to the safety measures. Precautions to be assured while conducting repairing works. Also, repairing maintenance TT must be done at authorized PESO approved workshop only. That means we have given them only with the intention that you want to repair the TTs.
Yes.
And if you want to participate, you can participate.
But if new treaty is provided to me with higher capacity.
And another, one more.
That to 82 page, but the paragraph.
Yes, 82, yellow sir.
That's what.
Yes. We assure you that replacement vehicle will be promptly reported with all required documents in the event the TTs are in a bad condition, and compliance with all IOCL protocols will be strictly ensured. We humbly request you to treat this an urgent and genuine case and allow exchange at the earliest to prevent further operational gaps and to maintain the uninterrupted service to IOCL. At that time, they were not giving these TTs for service. In the meantime, they participated. That is my only, it's not an emotional thing only, my lord.
One day, he has issued a letter.
My lord.
Has released this. And this is handed,
Lord, sir.
this one you have considered and given.
Both the letters, sir, also.
No, your first line at page 84.
You have not considered for purpose of this July thing, you have considered for service.
There's no reference of 31st July letter.
What's
It's
it?
only the reference of 1st August letter.
First line, sir.
No, sir.
No objection certificate.
Because
You can't shut your eyes.
so both the letters will read conjointly because
Why?
one is saying the treaty is
Sir, I'm
inoperative.
giving, I can give you multiple judgments on a notice,
Man,
on a notice.
but continuous.
That before initiation of a notice, before initiation of a suit or institution of the suit, some of the act says that the notice is to be given of 30 days. It appears that the notice was given.
Notice was
Then-
not given. One it was
Just
present,
one-
yes,
one minute,
because it is
sir.
in a bad condition.
If you think with a closed mind,
No, sorry, man.
I think I should not.
I have to.
When I'm talking
I'm trying to
about
understand also.
about a hypothetical case, don't go by your case. That's the whole problem. I'm not concentrating on this case. I'm giving you a hypothetical example. That a statute mandates that before institution, you have to give a 30 days notice. A notice was given. Suit thereafter was not instituted. Say after 6 or 7 months, another notice was given. And then the suit was instituted on the basis of a subsequent notice. If the analogy which you want to say is correct, then this earlier notice was also already there. Subsequent notice has no value, and therefore suit on the basis thereof is bad.
Cause of universe.
Supreme Court deprecated.
Right.
The principle is that if the subsequent notice is given, then it will be inferred that the earlier notice is waived. Implied. This is what I'm talking about, the principles which I am giving it from the West Bengal Principal Tenancy Act 1956 and 1997. There, before institution of a suit for eviction of a tenant, notice of a suit is mandatory that I'm terminating your tenancy. It was terminated, no suit filed, subsequent notice, same ground or other ground, terminated and suit filed, then the point was taken. How can you terminate a tenancy which is already terminated by you in the earlier? It says that is impliedly waived. If an authority have issued a no objection, now I'm taking a note. If authority has issued a no objection on the basis of a last written notice or a permission, that implies that the earlier notices or a permission is impliedly waived by him. That is what is the problem which we find on in a law, not on fact, in a law. Had there not been a reference of one letter dated 1A, we could have presumed something else. But no objection clearly says that on the basis of your request or a letter dated 1A, I am granting you no. That means objection, no objection to participate in another tender process. You can show this particular 2 trucks to be utilized and used in the event you become successful. Subsequently, he immediately offered that since I have already shown these 2 trucks there, I am giving you a better. And he did not say that till the time this better is replaced, I will take out this too. No, they can't. Uninterrupted supply must be ensured. And then you are saying the no objection is, that is what I'm saying. If you do not consider the law in that perspective, what to do?
I wanted to submit that piece recommendation only and one other
What is
point.
this? Somebody cannot change, cannot say that another ground. Can he not? And if the authority had considered that ground, what is the difficulty?
The only difficulty is he
Nothing.
never implemented. never
The
take. taken an NOC.
problem which I perceive is that you have engaged a contract here. The petroleum, the transportation of a petroleum is a very essential service. Because there cannot be any disruption. We are conscious of that. We will not definitely allow any action which would hinder us, which would impede, or which would even cause more the threat to our safety and the security. Because it's an inflammable articles and there should be a lot of
Yes.
safety measures that's to be taken. We are conscious. And look at that, the person who says I am giving you the latest one which has more safety gadgets, which have more capacity, which can ease out the burden. You can load more petroleum into it and I can transport it. And which is absolutely in conformity with the recent guidelines.
It is not, Your Lordship.
BS4, this is BS4 compliant. Yes, said.
What about the tank plus? I am saying the ITDC guidelines.
Sir, of the same capacity 20.
I know, madam, that is what is there. I know. So what is the difficulty on your part? I do not find anything.
May I summarize only two difficulties, Your Lordship? First, they never take the NOC before participating. Second, it is against the
Is there any embargo that you
5.1, Your Lordship.
you cannot participate without intimating? Please. Sure. You were referring a clause.
Clause 5.1 on the ITDC.
Where is the letter of rejection?
2.
No.
29 2025.
Objection when you withdrew.
29 2025. The cancel. Page 98, Your Lordship.
90.
Page 98. 98.
What are the grounds? Yes, I think so.
Lordship. May I read it?
Yes, please.
It is observed that you have participated in the HPCL tender, so and so, with the TTs already plying in contract with IOCL
Correct.
without obtaining NOC from IOCL. This is violation of clause 2.2.2.14.
8.2.2.14.
Yes.
Now, please
Enter
show me you have taken a clause 8.2.2.14. What it says? 8.2.2.
MBG guideline I have given.
Please, 8.2.2.14.
Yes, also. The page 24 of 27. The ITDC guideline I have just now provided.
Please tell me. I am at it.
Page 24.
Unauthorized use of TT outside the contract. Unauthorized use of TT outside contract. Then what is the remedial measure or
The next part.
consequences? What is the remedial measure and consequences?
TT self
Blacklisting. Blacklist him. You think? They have said they have not used this outside the contract. Still they are using it outside in the contract. They wanted a replacement. You have not allowed them to be replaced.
They wanted
This may invite that particular tender to be cancelled. But at least you cannot under this say there is a violation. The word use means in actual use. They are in actual use now.
the next point you also make kind of
What?
entering into a contract based on false
Now I am
documents and false information.
now I understand.
Also.
I am reminding you of a Maninder Singh Gil's journey.
My lord.
Can
Yeah, also.
you take that plea of 8.2.2.15 when your authority has not taken this? It is only under 8.2.2.14. Can you take?
Also, this ITDC guideline is wholly applicable to.
I am asking you if authority has invoked a particular clause and if the clause appears to be not applicable, can you improve the case at the bar? Can you bring out the judgment of Maninder Singh Gill 77 for the 97? What is the reference? 1997.
1978.
78. I was also thinking of 77.
1978, 1 SCC, page 405. Para 8.
1972, one, this is dialogue.
PIR, that's 70. PIR is here or SSC is here? SSC is here.
Yes, it is here. Yes. Yeah, yes, SEC here.
Yes, 78.
Yes. 1978, one, yeah, that's also one.
Yeah, yeah.
Yeah.
What is the, Q1? I think the first head note is very important for you. You don't have to go into this.
Yes, sir.
Clear. Clear. First, right hand side,
Well,
head note. You read.
University. When a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of an affidavit or otherwise.
What
An
you are
order-
doing, sir? Your statutory, let us see, your authority has taken a shelter of 8.2.2.14. You are going to say, no, 8.2.215 is also applicable. 16 is also, can you do it by virtue of this observation?
Certain orders.
So, close. You have to justify only 0.14, not 0.1.
But the ITDJ guideline completely applies as a whole.
Sir, then you are arguing against this.
No, I'm not arguing against this.
This is don't close it.
I'm not closing it.
It's a
I've
very
taken out.
important judgment followed till today. Followed till today. Read it. Not very easy to get away. Sir, the statute is voluminous. If a ground is taken off a particular section, will you come and argue that the entire statute has different sections? I can argue on any section. This judgment is an answer, which you are trying to make. If the guideline as a whole, one has to consider. But if you have chosen to invoke a particular provision, can you improve the case for the first time? Other provisions are also applicable. I am on that.
Well,
Show us this judgment.
in view of this judgment, you'll also because this
So 8.14 does not apply. Anyhow, can't. You have challenged which order?
Annexure 9 series, page 98.
Yes.
Page 98, May.
Register General. Is it in
The order of cancellation.
Mal,
the
cancellation of the NOC.
And where is that letter which talks about 8.2.14?
This letter, this particular,
the first order.
first paragraph, second line.
Oh, yeah.
Official yes.
This is a violation of ITDG.
Oh, yes. I was missing. I was attached NOC and all everything. I was
I'm sorry, Manoj, I was on my lips.
give me back that judgment.
I don't know.
So, judgment is something.
There are one or two, one factor thinking about it.
Same light balance. Light of 78.
The thinking in the line. That what could be the meaning ascribed or assigned to the word use.
Use.
Means use to use or put in use. Or capable of something else.
They probably mean
If I correctly remember what judgment it says that it should be actually used.
they also meant it, probably they're meaning it in that sense. Yes.
Because mere intention to use, having not actually used.
Laws also says unauthorized use. Unauthorized.
But one has to first find out the meaning of the word use. And then it is qualified outside the contract.
No. Further qualified outside the contract. Could be without permission.
Not taken off or taken off those parts.
No, we are unable to because it's still in the continuing in the vendor list. No.
That is why the word has to be assigned. We are showing those parts. To be used.
To be used. To be used.
Subject however to from the they are bringing for you of the word use.
9 minutes. For stumble submission, it should
Take
not.
up your lordship on this. The meaning and implication of the word use.
Most stumble submission should not come because of the.
So there is another safer way of doing that they have wrongly improved
Minutes.
and they cannot improve their case by referring to any other problem.
Also, the first judgment is Municipal Commissioner versus Gordon Das Bhanji. Municipal Commissioner Bombay, 52 Supreme Court is the first judgment. I don't remember the page, but please take out the page. Oft quoted, and that's also referred to.
Here constantly, this principle is still.
You can improve the case in the counter by giving.
Except in one case. That was in relation to Bihar, this examination scam case. Where certain inquiry, the CBI inquiry on.
This judgment is followed. This judgment is followed. Page 16. Yeah, 1952 Supreme Court, page 16. Well, it's my learned friend has pointed out a judgment. That is Vasu Healthcare Private Limited versus Gujarat Akruti TCG Biotech Limited. Yeah, 1917 Gujarat, page 152, wherein detailed consideration has been made and the conclusion reached therein by taking note of an earlier decision that on the plain reading of clause 2.21C CC of the CC Act 2015, the expression used must mean actually used or being
This
used.
is what I was,
Must
I had
mean-
that feeling of that,
Actually used or being used.
being used.
Further, that if the intention of the legislature was to expand the scope, in that case, the phraseology was likely to be used or to be used.
That is the difference.
Well, that's what,
Then the question of intention that.
what fell from your lordship, that to be used.
Introduces an intention.
Well, that's exactly the language.
Intent to use.
Well, that's exactly the language.
Actual user will not come, but the what.
Well, then it has to be actually.
Actual user.
Well,
An actual user is admittedly absent here because they are not permitted to issue taker to be.
it still continues in there.
Taken
And
out, they are
others.
not permitted. So it is not used for that purpose.
Well,
Can you give me that example?
Madam, this is AI 2017 Gujarat. 153. There's a
It is Supreme Court.
this has been referred on Supreme Court. This has been referred in the Supreme Court judgment, my lords. My lord, this is civil appeal number 7843 of 2019. Ambalal Sarabhai Enterprises Limited versus KS Infraspace LLP and another.
Sarabhai is a giant, that is all a commercial.
Commercial
Course act.
Courts Act, CC.
I believe it is.
2015. Bopan, AS Bopan,
Yes, Mohan.
AS Bopan.
I think it is more, relevant for the market and document. Yes.
No. Use this Commercial Courts Act.
Not really.
No.
Ambalal Sarabhai.
It's related to a mortgage deed, execution of a mortgage deed.
Well,
exactly.
The game, because it must be in relation to a mercantile document.
Man,
Under the commercial course act.
man.
Give that reference also.
Yes.
Yes, people may.
See, there is a reference of AIR online.
You will also record your submission that you are referring to the properties.
If I can give a short note of debit.
It's in SC 117.
And you are also referring the other process.
Clause 5.1.
Simply include that.
Well,
We have to hold, and then in this clause is there, and then the consequence is also provided, whether the other consequences you can drop it, that's another.
The AI reference is AI 2019 online, page, online 2019 Supreme Court, page 1170. Online, AI online 2019 Supreme Court, page 1170.
Interesting point, that's why you want to bother upon and cover. You have not assisted properly.
No, no, yesterday,
No, you did not. You have not thought of this point.
the second furnace, first one is 1952 Supreme Court was always there. Great.
It takes me 2-5 minutes. The case of the Nihari was a tenderer who seeks to challenge the award made in favor of opposite party number 7 under annex 12. That's 13. Well, the demand for the lordship's consideration would be from page 57 to 59. May I draw his lordship's kind attention to page 57.
What is that?
That is evaluation criteria for evaluation. Because my entire case is that according to the terms and condition and evaluation, I should have been given the award instead of the opposite party number 7.
Why?
So that is why I am drawing your lordship's kind attention to its terms and conditions. How
Yes,
the-
evaluation of technical proposals.
Yes, madam.
Yes.
Your lordship will see page 58 last. Has your lordship got it?
Yes.
They have allotted different marks for different specifications. Then the financial proposal shall be opened after the technical evaluation is completed, and only those bidders who score at least 56 marks in technical evaluation shall qualify for financial bid opening. Right now. Then I qualify also opposite party number 7 and 8 qualified. Then 59 is evaluation of financial proposal.
Yes.
Has your lordship got it?
Yes.
May I question? The total price exclusive of the GST as per price format F2 shall be considered for price evaluation. In the financial bid, the bidder with the lowest price shall be awarded the contract. This is one. However, exception is in case two bidders quote the same lowest price, then the agency with the highest mark in the technical bid shall be awarded. Then you have to again revert back to the technical bid to find out the highest mark. Here the proceedings of the tender papers are not there. I have asked to call for the records, but my representative was present, Milord.
How much marks you obtained in the technical bid?
Technical bid.
And how much marks they obtained in the technical
Milord,
bid?
the opposite party 7 and 8 got 80 and 80
80.
in technical bid.
Full.
Huh.
And how much you got?
I got 75.
75, okay.
Okay.
And the price bid was equal?
No, price bid of opposite party number 8 and 9 was equal.
And the contract is awarded to whom?
Opposite party number 7.
7, the
Seven
price bid was?
7 was, your Lordship will kindly see. It quoted, Lord, I have made an amendment and filed petition.
Yes.
Lord, your Lordship will kindly look at.
No,
page 50.
sir, let us understand, sir. Suppose your contention appears to be correct, then it is the award, the contract should be awarded to opposite party numbers 8,
8.
not to
If
you.
the opposite party number 8.
8 is not coming forward.
The opposite party number 8 is otherwise disqualified because he has already taken, and there is a condition, I will come to it.
And then.
Condition that you are, if already you are working for.
What is the price of
That
opposite
is-
party number 7? Was
Opposite-
the higher than you
Opposite
or
party-
lower than you?
Opposite party number 7 is 1 point above me. That is 13 lakh, 1 crore 33 lakhs 92,688.49. I am 1.33 crore 688.40. So that is not the point, but equal.
Oh, that is the main point.
Like equal bid was opposite party.
Sir, suppose the situation is that 3 bidders qualified for being considered.
Right?
Correct. Out of which it appears that 2 bidders have quoted the same price.
That is opposite party number 8.
Whatever, sir. Hypothetically, sir, forget about your case.
Yes.
Let us see hypothetical example.
Right.
Where 2 of the bidders, they quoted the same price.
Yes.
The third bidder quoted, say, the lower price.
Yes.
Then according to this clause 5.2, it is to be given to a lowest bidder,
Lowest.
irrespective of the fact
Yeah.
whether he has obtained 75 marks, 72 marks, or 60 marks
Right.
immaterial.
Right.
He has got the requisite marks in the technical qualification, fair
Right.
enough. In the event, it appears that all the 3
Equal.
have quoted equal.
Then
Then in that event, those who, the intending bidder who obtained the highest mark,
the technical bid.
he will be qualified for that.
Right.
He will be awarded. So in this event, in this case, you have, according to you, you have quoted the lowest price
Yes.
along with opposite party number 8. Opposite party number 8 was declared disqualified or not qualified?
Opposite party has to refuse it. That clause, let me draw your Lordship attention.
Refuse means, where is a,
He has to say that I will not, I have made him also a party member.
what?
I have. Let's see. Section 4, terms and conditions, clause 4.3 at page. Not just 4.3 50 49. Page 14.
Yes.
Allotment of district institution. An agency can work out of maximum 5 districts. However, agency can apply for any number of districts. So this
So it says that he can apply for 10 number of districts, but he will be allotted only 5.
one,
5. That's all.
he
Then
applied, the opposite party number applied for several districts
maybe.
and has already been allotted one in respect of one district, barring the district for which The bid has been.
So he is still within the cap of 5.
Eh?
He is still within the cap of 5
Yes,
because maximum is 5.
yes, yes.
So if he is allotted 1, then he is entitled to be allotted another 4.
He is working in 5 districts. No?
Where?
He is already working one, in already 5 districts he is working.
Sir, we are not, this language is such which does not really put a fetter whether he is in past what he has done.
No, no.
It is in presently that pursuant to this tender, he can apply for more than 5 districts, but he will be awarded only the contract for 5.
5 districts.
Correct.
So it is in respect of the entire state. This is in respect of Madhuban district. For 1 district. So he is already working at present.
That is in pursuant to the earlier tender. Please consider, because the language which is there, if I read it, an agency can accept work order, accept the word work orders of maximum of 5 districts. Then full stop. However, agency can apply for any number of districts.
That
shows that pursuant to this tender, it has no relation with the other tender already awarded to him.
B.
Yes.
In case an agency succeeded in getting work orders for more than 5 districts,
Correct.
other institution and for the competitive bidding process, then the concerned agency has to execute the work order of 5 districts and other institution within 7 days from the receipt and decline the rest of the district.
True. No, he has to. That is the mandate.
In this case, he has declined.
Declined for what? He has got the work order for other districts, 5 districts.
He should have been L1.
No, probably. I think the clarity has not come.
I think I am not clear.
No, I think I am unable to receive it
No.
very clearly.
That I don't have any doubt.
Sir, what I understood was A put a embargo or restrictions that one cannot be awarded the contract beyond 5 districts.
Let me go step by step. First is tender bonus. Anybody qualifying technical bid 56% gets a right of consideration in the financial evaluation. Then financial evaluation, lowest tenderer has to be
That is a separate issue. This is pre-stage of the technical and financial.
No. This is after. Only if you get an award, then can you decline.
That means, sir, pre-stage is why I say pre-stage. When a right is given to apply for endless number of districts, that means that at the time of submitting your bid, you can apply for any number of districts.
Yes.
Then the question is, if you are awarded a contract, then you cannot be awarded a contract beyond 5.
Right.
Up to 5. That means even if he is L1 in respect of the other districts, then he has to be weeded out from that district.
Yes.
So there is no quarrel in my mind in this regard. You are saying that he has renounced or given up this district. When he can renounce and give up, he can renounce and give up in the event he has chosen 5 districts already.
Your Lordship will see what is pertinent in that clause is Fourth three.
What he
Second
says,
years.
what he is trying to make out a case.
Mr. Mahanti,
As per the
Mr.
revised,
Mahanti, at page 5, paragraph 3,
yes,
subpara, with regard to opposite party number 8, you have described like this. Because he has been working since 2024,
yes.
its bid had to be rejected. So, that is not the criteria under 4.3.
Bidding process as per revised RFP November 2023. So he has been working since 2024.
Sir, let us see that he is working since last 15 years. But this clause 4.3 is not applicable in this regard, that his past contract will also be taken into consideration.
This comes from the interstate. Otherwise, this 5 district award will be meaningless in this if the contract is considered for 1 district.
I do not know this particular this tender is floated for this the purpose which
Yes.
is mentioned therein in respect of all the districts or in respect of some of the districts.
But even assuming my lord, your lordship is correct, my lord. But without joining issue, my lord, that proposition is accepted as correct proposition, my lord. Then opposite party number 7 would have been awarded.
8.
8 would have been awarded the contract.
The second principle is that a person who is discriminated or whose right is violated,
He
if
has
he
not-
chose not to fight, then what?
Then he abandoned his claim, then I will be L2. L3 cannot be by no stretch of imagination would be awarded. He will be presumed to have abandoned his claim or acquiesced to the situation. Then I am L2. If you go, lordship, but that is my submission. It is for your lordship to accept or not to accept. I am not there. Then I automatically I
Why so much of resentment in your heart?
No. That is, we do not dictate orders. We do not expect to control the court. We are only here to make our submission.
That's true.
Consider.
That's true.
So my tone may not be good because of
Why
the
tone?
age.
The tone is very pleasant. Why? What is the
Because
difficulty?
of the age,
No, it's always a pleasant one.
What I mean is, thank you, Mana.
No, I got your point. I got your point because you are banking upon 4.3 and that clause of the tender which says that in the event there is a tie, then the marks which he obtained in the technical bid stage will be taken as a benchmark.
I'm only looking
And according to you, that opposite party number 8 and you were actually L1, quoting the same price, identical price.
right.
So the consideration must be restricted to you, between you and the opposite party number 8. Opposite party number 7 is out of the fray.
Yes.
Correct. And if the opposite party number 8
Doesn't
is not interested, then you are the lone one.
no.
You should go steal a march on a vacant path. No difficulty.
That is, but this is a prima facie point. I want to.
So let us hear anybody is what you are for.
He is appearing, my man, he is appearing in
Yes,
Kerala.
what you say about this?
Sir, I'll explain 2 minutes.
Yes.
My friend has not given the bid sheet of OP number 7. I'm giving the relevant 2 pages only.
Bid seat. The price which you
Yes.
quoted was also equal.
Sir, also equal.
Right?
Actually, they have done some wrong thing actually that I will point out.
Okay.
So we kindly look at first their bid sheet. Kindly turn to page 97.
Of the
Sorry, page 97 of the rate sheet.
hey,
Page 97.
yes, sir.
Kindly turn to that heading, price format for the housekeeping service. They have given 1, 2, 3, 4. And the total is, if your lordship turns to
Yes.
1.6 left side, 1.6 then 2. I have got the 2. Total HR cost oblique month. Serial number 2.
Correct.
Total HR cost comes
Correct.
to 12
Crore,
12 crores 800.
no, 1 crore 28 lakhs
Yes,
96,000.
1 crore 58 lakhs 96 also.
Correct.
Now kindly have a look at the seat I have given to your lordship.
Yes.
OP number 7's price. Page 3 of the sheet. Page 3.
Yes. Give a copy to it. Yes.
Well,
So 1 crore 28 lakhs, 28 lakhs 96,000. But he's 96,000.
96,000,
Correct.
185.35.
And you are 185.35. You are also equal.
Exactly same thing. But now
You are also equal.
comes to the next page, man.
Yes.
Page 4.
Yes.
This was 3.1 service charges in percentage. 3.85%, 4%, 4.5%, etc. Not in amount.
Mm.
So 3.585% is by there, and I also quoted the same.
Correct.
Multiplying it comes to
4 lakhs 96.
496503. That
Correct.
percentage of the amount
Correct.
is 1/4. That is 1/4 mentioned by me. They have mentioned 1/3.
How can it be? It's a mathematical.
So it should have been 1/4. In fact, there also should have been 1/4. Because it is 136. Percentage is 136. They have to take only.
So actually, anything which goes beyond 5 has to be
Right.
equalized,
So it should
neutralized
be
with
one-
the higher integral number.
Petitioner and Opinova 8 quoted 1/3. Actually, it's not correct. It should be 1/4. I have quoted the correct thing.
Got you.
Is
Okay.
136.
I got it.
Well,
I got
and
your point.
that's how the total comes to exactly same, except 4849.
Oh. It is nothing. Brother.
It's all plain and simple.
Mr. Mohanty.
Just one.
And interestingly, Opinum,
No, he realized that it is a correct.
they had approached your lordship earlier. Your lordship dismissed their writ application with 25,000 cost,
Yeah.
challenging my participation. Sir, can you have a look at that?
Participation.
Sir, they have set up another person to
For that percentage do have once.
25,000 cost.
Who appeared in that case?
Oh, that comes to 4,96,503.1359.
This is.
So that
Yes.
that is why you have
1/4.
put it 1/4. Yes,
Right.
that will be 1/4.
It can be 1/3.
Third digit. Third
Exactly.
digit if exceeds 5 or more,
I will.
then
1/4.
No, this
Same
Yes.
tender.
same tender.
Yes. Before the opening of financial bid, they
Yes.
wanted me to be disqualified.
This is by Aviram Catering and Export opposite party number 8.
8.
Before the tender.
Same
What to do, sir?
Same
And who was appearing?
That is about
I
the-
think non-senior counsel.
that is about the eligibility.
Mr. Rakesh are here.
I have seen non-senior counsel,
No,
not designated as a senior.
no,
So we have to respect the standing of a senior counsel
no, not that way.
for paragraph 7.
No.
Paragraph 7 of the said judgment.
Yes. This was not the point.
You are concerned with the numerical figure in the paragraph 7.
Where this, your lordship is see, that is the opposite party number 8.
Sir, mathematics you also know, we also know.
Then
If it is 0.136 and then 0.14, you cannot go to that. It will come to 0.14. If they have quoted, that will be treated as equal. And once it is an equal, then they admittedly, you also say obtained 80 marks in the technical bit. And you obtained 7 bids. That's an admitted position. As per clause 4, as per the clause of the tender, that marks will be a benchmark.
it becomes same mirror, then
Same.
Yes.
The
Same.
agreement has been
Same.
executed.
Same.
What has been 15, we have associated 8.
So definitely we'll take into consideration.
Same is not the case. May I, lordship, taking my witness surprise,
Yes.
because I am given to understand that in the said proceeding meeting, both 7 and 8.
Sir, it is a purely mathematical calculation, sir. Purely because if you have quoted, if you have quoted the correct price at rupees 1 crore 28 lakhs 96,185.35, which they have also quoted. Only thing is, since the 3.5% of the service tax is to be added or calculated, if in the calculation you have gone with a more integral fraction and they have come to a near integral, then in that event you can't, because 3.85 for on your price and on their price will be the same. Can't go.
That is what I want to.
Sorry.
Say, my lord, your lordship puts it tomorrow for orders, I will prize your lordship after making a calculation.
What? There is no difficulty, sir, calculation. Sir, there is a certainty in the clause. You have calculated the service tax at the rate of 3.85, which is undisputed, on this particular price of 1 crore 28 lakhs 96,185.35. Correct?
Yes.
They have also calculated the service tax of 3.85 on the same price, that is 1 crore 28 lakhs 96,185.35.
I got your.
If both the prices base amount for the purpose of service tax is one, your calculation and their calculation differs. How it makes a difference?
Got your lordship.
State,
All right.
this price is the base price.
3.5 cannot vary.
Cannot on the same.
I have not calculated in that manner.
That's all. No, you have gone to a 3 integral numbers after decimal. 136.
No.
And they have ended at 214, because anything which is beyond 5 after the decimal is calculated nearer to, except for the rocket science is a different one.
No, I have gone by the total price.
Makes it clear.
Total price is one and the same.
Right, here it is written 7 and 8 and 27 has been written as 30. instead of 14.
That's not correct.
Huh?
No.
That may not be correct.
Ah.
No,
Correct.
that may not be correct.
No, it's a mathematical.
But
Nothing.
I have gone by that 13 and 14, That may be my mistake.
No.
I
No.
ought to have calculated it.
No, I mean the 3.8,
I go by the papers. I have not.
correct. 3.85 is a fixed percentage.
I get.
Noted.
Okay, sir. Obliged.
What is the other one? What to do? Paragraph 7.
Paragraph 7, it doesn't concern me. I have never approached you.
Sir, page 18.
I not wanted to.
Sir, page 18, ground B.
No. Paragraph
Page
7, I am
18,
not
ground
the
B.
petitioner.
Which?
Page 18.
Cost, total cost.
Ground B.
Then the entire proceeding has taken that 13 into consideration.
49, 40. That is B.
That is the amount.
So here-
So no difficulty.
So he has put this by reducing
No.
one point. That is the.
Point 0.01
So
difference.
your ground number B, you have
0.01.
made it to 48 instead of 49 because it has to
Where is
go
the-
to the next point.
Where is that,
Say because that,
the clause? We says equality.
that 4.3,
4.3 is a difference.
that 5.2,
5 point. Page.
page 59.
Page 59, 5.2.
Yes. The present writ petition at the behest The mathematics says if after dismissal, if it is more than 5, then it will be added to a first, the earlier preceding higher number.
Is it 6? Therefore it doesn't.
It should be 4.
They have taken that format 2 says only 2 digit has to be taken. So that is why they have taken this 2 digit.
Anyhow. Yes, call the next. Yes.
Item number 51, sir.
No, what is uttered by the senior?
I'm sorry to hold you up.
No. What?
That's what he said, told me.
Oh,
On his way out, because he promised my lord that within 10 minutes the matter would be over. So it went on for more
it
than
should
1
be over. It should be over within 10 minutes. That's he's correct.
The opinion that a writ application should take more than 10 minutes.
That's true. That's true. Yes.
Incidentally, my lord, Mahanti was the Advocate General, Ashok Mahanti, senior advocate. Sir was also the Advocate General of Calcutta. When I took over, when I was the Advocate General, he was also the Advocate General. So we had a lot of interaction there in Calcutta.
So all of them are.
That is how we have it.
What is this? Other side? Who is there?
Deputy Solicitor. Deputy Solicitor.
Union of India.
Who is appearing for Union of India?
DSG.
there.
Yes, Mr. DSG, your matter is being called. It's fixed at 2. Please unmute your system. I'm not
Yes,
audible. Yes.
Yes, my lord.
Yes.
Yes, sir. I'm sorry, my lord, I could not follow the item.
Yes.
51, sir.
51. Yes.
Wait, please, your lordship. My lord, this is in respect of my lord siding, in respect of which one which was allotted in my client's favor for the purpose of setting up, my lord, a siding for transport of goods by the
Railway siding.
railway side. Now, my lord, for the purpose of this, my lord, there is a number of notifications issued from time to time. And one of the notifications is this, that this is by way of liberalization policy, the government of India undertook this particular exercise. What happened was this, that by the notification they said that if there is in respect to this private-public partnership, if you procure the private land, you set up the sidings, then there are certain benefits to be given to you. Whereas if you take the government land, then there are certain other things to have to happen. One of the things is this, that if you can set it up in a private land which you acquire by yourself, then you pay only 5 crores of rupees security. If you take it on the government land, then you pay 10 crores security. But I was one of the persons who came forward. And my lord, my offer was accepted. I deposited 5 crores of rupees by your security. And my lord, I shall just place before lordship a list of dates which will chronologically show your lordship that from the time, my lord, this particular contract was awarded to me, up to the date of, my lord, foreclosure of the contract, throughout, my lord, railway had been with me. And there had been absolutely no objection with regard to the way I had been undertaking the work. It's a huge work. But of course, I didn't have any idea until I looked into the matter. Because your lordship knows, my lord, the railway lands are always high. On the side, my lord, the paddy fields and cultivated lands are there. So when you construct a siding, you will have to build it up
You have
the embankment.
Yes.
And the embankment, the 20 acres of land was purchased by my clan, privately purchased by my clan at the instance of the government of India for the purpose of setting up the siding. So 5 crores of security have been, I have, my lord, procured the land, and that particular land, my lord, on that, a substantial work of siding has been done. For example, my lord, the first of all, the soil has to be put in there. Thereafter, my lord, the ballast which will be put. Thereafter, my lord, the stone chips will be put. The whole place has to be compacted.
To raise the
To
height.
raise the height. And my lord, it is not a small area. As I said, my lord, 20 acres of land, which is, my lord, I found, I calculated, the length is 1.5 miles. And my lord, the width is more than 100 meters. Because what is going to happen is this, the train lines are to be laid, first of all. That has to be connected to the main line. And my lord, by the side of the lines, one has to have sufficient amount of space, well compacted, so that, my lord, dumpers can come, excavators can come for the purpose of extracting, my lord, coal from the, either from the lorry into the wagon, or from the wagon into the lorry. So I'm just explaining to your lordship the topography of the place thing. So this was being done for quite some time. And this is, my lord, more than construction of a 15-story, 16-story building. Because, my lord, the work has to be done in a rustic area. The stones, ballasts, etc. will have to be brought from outside. The rails will have to be bought. The sleepers will have to be laid. There was in the case of my client, my lord, there was the bridge. There was some kind of a nala. A bridge had to be constructed on that for the purpose of constructing this. And this had taken a lot of time. I shall show to your lordship from the documents which are there on record that throughout, my lord, the railways had been in communication with my client. And at no stage they had complained of any lackadaisical attitude in the matter of, my lord, doing the work of construction. At no stage. I say that without any fear of contradiction. There is not one document. But my lord, what, and on the contrary, what they had been doing is, and this is, my lord, all substantiated by documents. What had been doing is asking me from progress report. And I had been giving progress report from time to time. And the last one that they gave us is this, that you give us the target date. You give the target date when you will conclude. We said that we shall give you the target date. But there is one land license agreement has to be executed between the railways and my client. What is that agreement? That agreement is this: from the main line, there's a connection is to be made to the branch for the purpose of going into the siding. Now that particular area where it will come and meet the main line, that an agreement has to be made by the railway with, so I cannot give a target date, I cannot complete the work until, my lord, it comes and meets there. So I had been insisting, give us the land license agreement so that we can sign it and we can. They did not do so. In fact, there are internecine correspondence among the railway authorities saying that, look, one authority of the railways is telling the other authority that we are not being able to do the land licensing agreement because the valuation that you have given is of 2011-12. Give me the present valuation. So, the land licensing agreement could not be done. I am not going to put too much emphasis on that. But what I am putting my emphasis on is this. You lead me up the garden path. You tell me, do this, do that, give me this, give me that. And throughout, you have been keeping an eye on me. Because after all, it is the railway siding which I am constructing. And you never complain of any lack of diligence on my part. On the contrary, you were asking for the program. Now, in a situation like this, One fine morning, you issue a letter that I am foreclosing your contract. Reason is this: there are other parties there. You are not. You do not seem to be interested in it, and therefore I am foreclosing the contract. So we tell them that look, we have done this work. The sleepers are lying over there. The rail lines are lying over there. Signal materials are lying over there. I have constructed the bridge. I have procured this land. What they said is they relied upon one of the notifications or circular, railway circular, on the basis of which they contended that we have foreclosed in pursuance of clause so and so. What we demonstrate before, we shall demonstrate before Lordship is that that particular clause is not applicable to me at all. So the basis of their termination, the foreclosure, in my respectful submission, is illegal and arbitrary. That is the first point. Second point is this: admitted this is a construction contract. Your Lordship notes under Section 55 of the Indian Contract Act. In a construction contract, time is never the essence of the contract. So if the time is not of the essence of the contract, the law is very, very clear. Since 1979 Supreme Court, I shall place it before Lordship, which says that if time is not of the essence of the contract, and if you want to you are complaining about non-functioning, non-doing of the work, then you will have to give a notice, making time an essence of the contract, telling them that look, I am giving
You have to redress whatever the shortfalls are.
and that has to be done. If you do not do that, the language of the Supreme Court is that the termination or foreclosure is illegal. This is my second point. My third point is this: I have, my lord, by reason of the transactions between the parties, my lord, I have acquired some kind of a right, and I have got, my lord, I have, my lord, in the meantime, I have acquired a lot of liabilities. I have incurred a lot of liability. Now, that being the position, when you are terminating the contract, you are really, my lord, affecting my civil right. Without notice to me, without giving me a hearing, you cannot terminate that. On that, my lord, there are judgments. These points have been taken. I am not taking these points for the first time. Remember, my respectful submission is this: that this entire termination of the contract or foreclosure of the contract is contrary to their own circular. It is contrary, it is in violation of the principles of natural justice. And thirdly, my lord, it was done in an arbitrary manner, therefore, my lord, violation of Article 226 of the Constitution. So on these three grounds, I have challenged it. I am respectfully submitting to your lordship on the basis of this. Unfortunately, the learned trial judge, my lord, had, when delivering the judgment, had taken note of, kindly, my lord, come to page, and this is, my lord, where I am joining issue. I say that perhaps this shouldn't have been done. My lord, kindly come to page 59 of the paper.
Internal page of the judgment.
Internal page of the judgment.
At the bottom right-hand side.
Yes, it starts at page 16.
16.
Of 22 page judgment, 16.
Yes, 16, yes.
Paragraph 17. My lord, I have...
In the present case.
Yes. In the present case, this court has painstakingly gone through the mountain of communications placed by both the parties. The ESP of the proposed private siding was approved on so and so. Bridge drawing was approved in 2013. Construction of the private land of the proposed private siding usually commences at this stage. There is a major connectivity construction stage that marks the end of the construction, which is the construction of the takeoff portion of the proposed private siding on railway land. Well, this is railway land, and this takeoff point, this should be takeoff point. Takeoff point is where the siding connects with the main line. For this land, a land licensing agreement is required. The court has noted that, and this is an agreement which the government has to enter into with me. However, this stage, though major, arrives at the fag end of the construction. The DPR approval letter dated 25/1/2010 contains some pertinent clauses. This court deems appropriate to reproduce. Then, my lord, the proposed private siding should be constructed wholly on private land, as no railway land will be spared for construction of private siding except the takeoff portion. The land licensing plan incorporating the observations of DPR approval must be prepared and submitted to the railway with the engineering tracing plan for its approval. Well, this was done by us. Any construction work of the siding proposed on the railway land will only be permitted after approval of land licensing plan and execution of the land licensing agreement. This is a clause by the learned judge has been pleased to court. And I said this agreement was not executed by the railways. And repeatedly I have gone on, my lord, asking the railway to execute this. And kindly see, my lord, trace it here. Any construction work of the siding proposed on the railway land will only be permitted after approval of land licensing plan and execution of the land licensing agreement. What is being said here is this, that you could have constructed your portion and land licensing agreement would have taken some time. Then why couldn't have continued with it? We did continue with it, and we had been clamoring for this land licensing agreement, which the government did not execute. And our one of the most substantial submission which had not been recorded by the court is this: the target date which the railway had been asking us to give, we could not have given the target date unless my lord land licensing agreement had been executed. The siding agreement has to be entered into between railways and Durgapur Metallics as per extant rules and guidelines laid down by Railway Board and in the court. You are requested to approve the Chief Commercial Management Office, etc. Kindly then come to para 18. Then you are requested to please submit engineering siding plan. This has been done by us. There is no dispute with regard to that. And land licensing plan. This was also done by us. 18. A bare perusal of clause 16 of DPR approval letter reproduced above would highlight that only construction on railway land may not be commenced before the land licensing agreement is entered in. Why has the petitioner company used this as a crutch not to continue and complete the construction of the other private land portion of the project? But my respectful submission is twofold. There is no, my lord, no evidence on record to show, my lord, that I have not, my lord, completed or, my lord, tried to continue and complete the construction of the other private land.
That is what it says, that actually the land licensing agreement is very much necessary for the reason that there may be other government land which may be utilized or which may be used for the purpose of laying the rails.
Right.
And then connecting it to a means the section of the this is what is required.
And
So the learned judge was of the view that that is what is a separate issue. But so far as your own land are concerned, which you have acquired from your own resources, and the railways has no role to play, you could have completed constructions there.
Yes, of course. I was complete. Not only I was completing the construction, I had undertaken, and the work was going on. And what I am on is this, my lord. If I had not been, my lord, diligent in this matter, then what the railways would have done? Simple thing is
But that was not a reason for, was it a reason for termination?
No. Yeah, I shall show to your lordship, my lord, from the document corresponding. I have prepared a short list of dates for your lordship. Kindly look into it, and I am sure, my lord, I will be able to convince your lordship.
So that was not a reason that you have not completed your, so far as the construction at your land is concerned or something.
They had been, in fact, monitoring our work on our land. Naturally, my lord, I don't grudge that. The railway will have to look into what I am doing in my land, on my land. And they are coming there, asking us to do this, do that, construct a new bridge, pull down that bridge, construct a new bridge. But they had been doing, my lord, had been cooperating. Suddenly, my lord, that particular letter had come. I shall show to your lordship. Then, my lord, can you see? The drawing of the proposed private siding of Mr. Durgapur Metallics has been approved by the engineering department and registered under so and so. The land licensing plan was approved. So, my lord, land licensing plan was approved. And then the land licensing agreement was pending with the railway authority. The court has recorded that. The land licensing agreement was pending with the railway authority. Therefore, the railway authorities can be faulted for not being prompt with the land licensing agreement. However, there is no reason why construction was not undertaken in the private portion of the siding for so many years. So where did the learned judge get it? I am very humbly, respectfully, putting this question. The chronology of event clearly establishes that the petitioner had ample opportunity and time to proceed with the construction on its own private land. With the detailed project report DPR approved as early as on 25/1/2010 and subsequent approval of ESP on 19/11/2010, these are all preparation and they are approving. And bridge drawings on 26/2013, there remained no substantial impediment to initiate and proceed with the construction on the private siding on the non-railway land. Clause 1 of the DPR approval letter categorically notes that the private siding is to be constructed wholly on private land, save for the takeoff portion. Thus, the petitioner's failure to utilize over a decade's time to carry forward its own share of construction, despite clearances and instructions, cannot be justified. Well, I pause here for a moment. I have got twofold submissions to make on this. First of all, there was no complaint from the railways over this decade for not working. This is not a child's play. It can't be done, my lord, overnight. Well, this 20 feet deep, my lord, on the two sides. On that, my lord, the embankment has to be constructed. 20 acres of land I have bought for the purpose of that. The court should not take note of that. The court should not look into the fact that there is no correspondence from the railway to us complaining of not functioning. These are glaring evidence which the court had ignored. I am sorry to say. They were kindly see. The petitioner's inaction on private land construction cannot be glossed over. I only put it in the question form. Where did my lord the learned judge get this from? This is, my lord, a perverse finding of fact, because there was no evidence on this. This prolonged inaction militates against any claim of arbitrariness in the withdrawal of administrative support. For the first time, this complaint had been made to the railways in their affidavit in opposition, which was filed 4 years. 4 years after, my lord, the direction was given. The railways, my lord, sat over this for 4 years. Railway is complaining that I did not construct the siding, my lord, properly, on time. I delayed the matter. And the railways had been waiting for 4 years to file this affidavit in opposition. And for the first time in the affidavit in opposition, they tried to justify their action by, my lord, making this incorrect statement. The next paragraph. The withdrawal of permission by the railway authorities cannot be characterized as arbitrary or unreasonable, particularly when seen in the context of the petitioner's protracted inaction. I pause there for a moment again. Even assuming there was inaction on my part, they could not have terminated the contract without giving me notice, making, my lord, time the essence of the contract. This entire action is bad. It is in court has said it is void. If, my lord, they do that, it is void. Why? It is illegal. And therefore, my lord, I say, first of all, there is no substance, no, my lord, evidentiary backing of in the first sentence of para 21. And second submission is, again, my lord, I am repeating, the second submission is this could not have been done, even if, my lord, I had been delaying the project without, my lord, the railway first, my lord, making time the essence of the contract. Clause 12 of DPR letter mandates that construction on railway land may commence only after, again, my lord, can you know, the construction on railway land may commence only after land licensing plan is approved and a formal agreement is executed. However, this stipulation does not restrict or bar construction activities on the petitioner's own private land. I would request your lordship to find any statement in this, my lord, recording as to what I had done on my private land. Nothing is there, excepting, my lord, this bold statement that, well, the there is no construction activity in the petitioner's own land. The railway had approved the relevant drawings and communicated the process forward. The petitioners relied on the pending land license agreement to justify its total inactivity. Kindly note the words total inactivity. Ignores the project structure itself. The authorities, being custodians of public infrastructure and revenue, are well within their administrative rights to revoke permission or reassess feasibility where the beneficiary fails to demonstrate seriousness. Well, I submit to your lordship, there is total lack of evidence on this. On the contrary, if the learned judge had taken note of the facts which were already on record, perhaps the learned judge wouldn't have come to this conclusion. I ask this only one question, that a party for whom I am working, if that party never complains that you are delaying the whole project, you are dragging your feet, the usual thing, then my lord, how can the court come to the conclusion that there has been inaction on my part?
Yes.
Continued reservation of railway resources, land and administrative time for a party. Note this word, railway resources, not a penny had been spent by them. I had to procure the land. I had to furnish security. I had to procure the materials. I had to, my lord, fill up this. I had to create the embankment. Railway had not done anything at all. This is, my lord, the railway had entrusted me with the work for the purpose of doing it on behalf of the railway. They say, my lord, this is public-private partnership. But, my lord, I respectfully submit to your lordship, my lord, it is hardly partnership. It is absolutely one-sided work by us for the railways. And I'm doing it willingly. Why I am doing it? Your lordship can ask me, why are you doing it? Are you doing a charity? I am not doing a charity.
So
This particular side,
it's not a partnership, but partitionship.
Yes, sir, it is like what? My lord, I submit to your lordship, my lord, that yes,
Segregated one.
my lord, the reason is this. The reason is also my selfish motive, not that I am doing it as something, a charity to the government. My interest in it is this, that if this siding is constructed, then
I got your point.
My-
You are just trying to say that there was not even a iota of piece of paper from the day when this particular tender or whatever the contract is executed with you with the railways. They were all along keeping or monitoring the entire progress of the work. They were keeping you under surveillance. They were instructing from time to time what to do and what not to do. And you have been doing the work, whatever. Since the laying of, there are certain constructions which requires the railways agreement to be entered into,
Yes.
which is paramount.
land licensing.
Land licensing agreement. The preparatory things which is required for execution of such agreement has also been done by you by submitting the plan and all everything. But they did not care to communicate that you come and execute the agreement, we are going to execute it. Rather, you say that there was one communication which shows that internal communications between them, that the price which is quoted is of the past years, quote it, ascertain it of the recent year, and that means that they were contemplating to execute the agreement with you.
Absolutely. Absolutely.
That is what one can reasonably infer from there.
Absolutely.
But suddenly one fine morning, they slapped you with a notice and then say terminate. And the termination was founded upon a ground which is non-existent.
Well, that is by respectful submission. Now, my lord, the reason I tell you, lordship, what should I say, the factor which created all this problem is, with regard to, my lord, a certain amount of deposit. Apart from 5 crores, certain amount of deposit has to be paid on the basis of, my lord, the volume of the construction. That was, my lord, assessed at, my lord, 8 lakhs and odd. We paid that. They, my lord, they revised it. And they said, pay 60 lakhs of rupees more by way of that deposit. To that we said that, look, we are expending all this amount of money. Why don't you have it adjusted against the security deposit of 5 crores that I have deposited with you. This, my lord,
Avoid them.
they completely earned them. And the result was this, that first of all, they said that you pay this amount of money, to which my lord we agreed. We said that very well, we shall pay. But nonetheless, in the meantime, the letter had come saying that we are foreclosing you. 3 lines later, I shall show to your lordship. And my lord, relying upon a particular clause of the circular, which clause was not applicable to us. So, my lord, the foreclosure was on the basis of a fact which was not applicable in our case. So, I shall show your lordship that. That is another infirmity which, my lord, perhaps had not been taken. And, my lord, then, my lord, the learned judge has been pleased to go on, my lord, this.
Settled principles. Then he proceeded to recapitulate the settled principles.
Yes.
Paragraph 22.
Yes, ma'am. Paragraph 22, settled principles of law.
Yes.
Kindly, my lord, paragraph 23. Again, kindly come to that.
Hmm.
Judicious allocation of monitoring of limited public land. This is the basic fallacy in the judgment. It is not a public land. The government has not given me any land at all. I had to buy that amount of land.
Yes.
It's 20 acres of land. The railway authorities, I think, my lord, completely misconceived the situation. The railway authorities are responsible for judicious allocation and monitoring of limited public land and infrastructure. Holding these resources indefinitely for a private party that has shown no proactive engagement undermines the public interest and planning. Well, I pause here for a moment. I have been landed with 20 acres of land. I don't know what to do with it. And I have got, my lord, the siding almost complete. Lying there, the slippers are lying, the rail lines are lying, the signal materials are lying, and my lord, they are being destroyed in the rains. My lord, this is the situation is this, my lord. This is, I am very respectfully submitting that this is a wholly arbitrary action on the part of the railways which has taken. Well, I shall take your lordship straight to the document. Well, before I do that, your lordship will kindly take, my lord, the impugned letter first. I think I shall give your lordship the factual background there. Lordship will please take the impugned letter.
Sage.
And I'm just give your lordship. Can you give me 1 second? So behind hand up to your lordship, a list of dates which I shall hand up to my learned friend also. A copy of the list. If there is any mistake, kindly that will be entirely my mistake because he has been prepared under my supervision. Give 2 copies to your lordship. Well, kindly take the chronological list of dates, the impugned letter, the first impugned letter in the month of March, item 24. 29th March 2017. I was starting from the end because it will be easier for your lordship to appreciate the submissions I am making. Well, kindly take page 173. This is dated 9th March 2017, written to my client, by my lord.
Agreeing that proposal, the principal approval has been granted, in principle approval.
Kindly note this, the first paragraph. In principle approval of the siding proposal on private land between so and so, granted by this office on so and so, the DPR, which was prepared by my client, submitted by your.
No, it will be, there is a timeline for approval of this land licensing, the agreement, a plan also is given.
But that is the year, lordship will kindly see this. This ESP, that is my engineering scale plan of the proposed siding was approved on so and so, and Alteration of ESP was approved on 22/11/2011. Thereafter, land licensing plan of the proposed siding was approved. So, I gave the.
That's true. That is what I'm
And
saying.
they did not execute that. Then, in reply to this office letter, they said so and so, you are once again updating time frame. Kindly note this. Office letter dated 24/2015. This is at page 2, page, my lord. I shall give you a lordship, page, I think, 163. You are once again updating. You are once again updating the time frame for completion of the pending work by your letter dated 4/5/2015. My lord, kindly come to page 163 once in this collection. 163. Just stop, pause here for a moment and kindly come to page 163. 4th May 2015. Written to the Chief Transportation Planning Manager. And here, the bridges which has been constructed earlier, we constructed the bridge, have been dismantled at their instance of the railways and shall be built as per approved plan of the railways. Photographs of the dismantling bridge are enclosed herewith. All sleepers and rail lines are at site. The site has been leveled for laying the ballast, sleeper and tracks. All P-way, that is pathway, materials, pathway on the two sides of the rail, are also lying ready at site. Photographs of the same are also enclosed along with. We are still awaiting the land licensing from the railways. Kindly note this. We request your good self to kindly extend the RTC, that is the Railway Transport Clearance, for a further period of 18 months, within which we should be able to commission the siding. Well, this RTC, by the way, had been discontinued, and the railways wrote to us saying that you don't have to bother about RTC because it's been discontinued. You don't have to. I shall come to that. We are once again updating the frame of completion of the pending work. At page 164, my lord, we have given it 3 months, 6 months, 9 months to be completed. There are some which have been completed. Earthwork has been completed, blanketing completed. There are certain at page 165. We have given this. Well, I would have expected that if they did not agree to this, or they would have said that why are you taking so much time? Why are you dragging your feet? They should be the opportune moment to write to us. They never did that. They accepted it. And on the contrary, kindly come to page 167. This is, my lord, senior DN Company Southeastern Railway is being written by Mr. Dubey, Deputy Chief Engineering Works. He is writing, after getting that, the subject proposal for fixing land licensing fee of siding Mr. Durgapur Metals, my client, is under process at the headquarters. It was observed by the letter, this office letter under reference, that the land value furnished in your proposal for the surrounding area as supplied by the sub-registrar so-and-so pertains to the year 2011-12. However, as per Railway Board Master Circular, para 5.3, for fresh cases, current land value to be considered for fixing the land license fee. Hence, it is requested furnish current year land value of 2015-2016 sub-registrar so-and-so certified by concerned sectoral so-and-so. Now, this is being written on 10th of June 2015. They themselves are not not ready with the land licensing. But my supposition is this, that when a party is complaining of the other party not doing the work properly, I would expect, and anybody will expect, that there should be something on record to show that there must be a warning. That what are you doing? For all these years, you are sitting over there, you are not doing anything. After all, what I am doing is on a private land. And you are taking advantage of my service for the purpose of construction of the railway siding. After I have converted the private land into which is fit for laying the siding. Now, absolutely no complaint at any point of time. On the contrary, they are themselves internal writing is saying so. Now, kindly come back to page 173. The letter, the impugned letter, one of the impugned letters. Kindly see this. I have said, I have placed before your lordship In reply to this office letter dated 24/2015, kindly note the letter has been written on 9th March 2017. In reply to the office letter dated 25/24/2015, you informed that you are once again updating the time frame for completion of pending work, while your letter dated 4/5/2015, which I showed to your lordship. Since then, neither any time frame for completion of pending work nor any positive reply has been received from your side. You will appreciate that railway cannot keep the approvals open beyond a reasonable period of time because this might deny opportunity to some other potential investor at your referred location. A considerable time has already elapsed. No action has been taken. It is therefore concluded that you are not really interested to develop the above mentioned private side. This is the first time they are coming out with this case. And then, in view of the above, the competent authority
They withdrew everything.
My lord,
They withdrew everything.
withdrew everything and kindly see has decided to foreclose your proposed siding between so and so. This is without prejudice to the right of the railway administration to forfeit the non-refundable registration fee along with codal departmental charges already paid. So 5 crores of rupees, 16 lakhs of rupees, all gone. The railway has pocketed it and railway said that I will not return. Note this kindly. After this happened, we wrote a long letter. I'm not troubling your lordship at the moment, at page 174 to 176, 3 pages letter. Then, my lord, again we wrote without prejudice on 21st March 2017 at page 177, explaining the whole thing and telling them that, my lord, kindly come to page 179. See the last paragraph of the letter. Therefore, in consideration of the foregoing facts and circumstances, and as per the extant policy guideline applicable in our case, we most humbly request the Southeastern Railway Authority to revoke and rescind the said order of foreclosure of siding project issued by your letter dated so and so to prevent irreparable losses and damages for which railway would be responsible. Instead, we sincerely request your authority to initiate necessary action so that land license is due executed along with the permission to work on the railway land involving this project. Now, my lord, then Southeastern Railway wrote this letter at page 3rd May. And there, my lord, kindly, my lord, again kindly see what they're writing 3rd May 2017. The claim of railways for an amount of fees 16,59,000. This is, my lord, the revised.
That revised one from 8 lakhs to 16
Codal
lakhs.
charges, revised codal charge, was intimated to you by letter dated such, giving you full and final opportunity to deposit the amount within 7 days. You did not deposit the said amount. However, you had requested by your letter number 1 referred to above to adjust the said amount from the non-refundable registration fee deposited by you as per clause 3 of FN circular number so and so issued by Railway Board governing the iron ore loading sidings. It is reiterated that departmental codal charges are levied for availing of the railway's technical services for according to different approvals related to construction of private site. An amount of 2% of the estimated total project cost is to be deposited as per the railway norms, according to the stages of approval of the detailed project report, engineering scale plan. There is no provision in any of the policy guidelines issued by the Railway Board to adjust the amount of rupees 16 lakhs from the non-refundable registration fee. In this view of the matter, it may kindly be noted that the amount due against the departmental codal charges cannot be adjusted against the deposit. Kindly note that this letter is written on 3rd May 2017. There is not a whisper of any complaint in the party, accepting non-deposit of this amount of money.
Even at page 181, the first paragraph,
Yes.
last sentence.
Instead, we sincerely request your authority to initiate action so that the land license due is executed along with permission to work on railway land involved in this project. the company is prepared to go ahead with the siding work further only after completion of the land licensing formality.
So there, even
This
if they
has been
withdraw and foreclose the entire thing, their
Yes.
intention is to continue. In an earlier letter at page 173,
Yes, one.
they say we want to abandon it
Right.
and do not want to go with ahead
Yes.
with the
So
proposal.
we foreclose that.
But here it they says no, we can continue with this.
And then, my lord, kindly come to the letter, which is, my lord, at page, this impugn letter again.
Oh, this is a quotation from the earlier letter. Sorry.
The quotation of the earlier letter is the first paragraph.
9/3/17.
No, there is no quotation which I find. Oh, no. Oh, there's a to prevent the irreparable. That's a quotation.
And, my lord,
9/3/2017. Yes.
kindly, my lord, come to the last paragraph, what they are saying. They are not angry with me. They're very considerate. Kindly see, my lord, what they're licensing of or handing over of the railway land cannot be a hindrance to carry on construction activities on private land. It is unfortunate that the private siding was not constructed in the private land on the plea that railway land was not licensed to you, and approval for construction of the siding cannot be kept valid for all times to come, as it may deprive other potential customers of the railways. However, you are free to apply afresh for construction of a private siding at your preferred location, which will be considered de novo on merit under FM number. This is something. What is this they're talking about? They say licensing or handing over.
They say that scenario which was there has elapsed, has gone. Now you can moot the new chapter, come out, give a proposal, we'll think it.
And in the meantime, my 5 crores is lying. My land is
Expecting further 5 crores from you.
Again, for 5 crores, perhaps they will demand. And when the land is with me, what do I do in the land? If I don't construct, if I am not permitted to construct the siding on that land, I cannot convert it into a football ground. It is 1.5 miles long. That area has gone into the meadows, into the field. My lord, kindly see, this is not the end of the matter. Kindly come to the letter. This is your lordship will be pleased to take the list of dates. 6 June 2017, the last date.
186.
Page 186. This will, my lord, clinch the issue. Kindly come to this. They are now justifying that impugned letter of, my lord, the 9th March 2017, which is at, my lord, page, which I have shown to your lordship, my lord, page 173. Now, what they are saying, your representation, by letter referred to above, has been examined. The siding proposal was closed in accordance with para 2.4. Note this. Para 2.4 of Railway Board FM Circular number 18 of 2014, dated 29/9/2014, for prolonged non-response. Then, the reason for closure of the proposal was explained in detail by this office letter date number 2 above. You may apply afresh under FM Circular number 11 of 2016, which will be considered on merit. The railways due of rupees 16,59,000 may please be deposited on account of availing railway technical service as demanded. So,
what technical service? If everything goes, then what more technical service?
Nothing is there. So, what they are saying is this: I am retaining 5 crores. You have paid 8 lakhs. I am going to pocket it. 16 lakhs you have not paid. You paid, and your contract is there. Before that, before your lordship, kindly take this. They are justifying this foreclosure on the basis of para 2.4
Correct. Of the FM circular number 18 and you being non-responsive.
My lord, kindly take that particular.
Where is FM circular number 18?
Yes.
At
this
what
is what
page?
I wanted to show to you, Lord. Circular number 18 is, my lord, at page.
187.
187.
Next page.
kindly come to that. They are relying upon this 2.4 for foreclosing. This is the only clause which entitles them to foreclose. There is no other clause. Kindly, my lord, come to 2.4. My lord, page 187, before your lordship comes to 2.4. Very well, 2.4. Let us read 2.4. After issue of freight marketing circular number 12 of 2008, there may be some investors, note this, who were given in principle approval but have not constructed the siding and who are no longer interested in constructing the siding. Stop, kindly stop here for a moment. Therefore, there may be some investors who were given in principle, but the spelling mistake, it should not be principal. It's not a college. It's a principal.
SPLE.
Yes, PLE. Approval, but have not constructed the siding. Well, your lordship will be surprised to know that in principle approval to us, the record is there, I'm showing your lordship. It was, my lord, given in September 2007. Before this date, kindly again read. After issue of freight marketing circular number 12 of 2008, there may be some investors who were given in principle approval. Therefore, after approval, after marketing circular number 2008, those who have been given approval, this particular circular, fresh marketing circular, is concerned only with this, are no longer interested. A review should be carried out for these approvals by a committee comprising of so and so. The case files of deciding no longer coming up should be closed. So this is the closure provision. This exercise should be completed in 6 months. But I submit to your lordship, 2.4 doesn't apply to me because my in principle approval was given in September 2007, and that is a part of the record also. Your lordship will please to, if your lordship wants to know, well, a list of dates, kindly see my chronological list of dates. In principle approval was given when? Kindly, my lord, come to 7 September 2007.
So according to you, this FM circular number 18 or particularly clause 2.4 is applicable only where the in principle approval is granted after the marketing circular number 2 or 12 of 2008. Any in principle approval granted prior thereto will not be affected. So it should be in between 2008 to 2014.
Right.
Those are the cases which comes within the purview.
And my admitted position in principle approval was given to me in the month of September 2007.
133.
And that is at page 133.
No, there was one letter which you just showed that in principle approval on such and such date, and then the PSP approved on such and such date. Yes. And then the master land or licensing plan is also approved in 2012, which I have
Yes.
seen that. First paragraph.
I shall give you a lordship.
No, I have. I can give you. I've tagged it.
9th month.
I shall give you lordship the date.
Yes, at page 173. There is no difficulty. That's the first paragraph.
So, well, there is no dispute with regard to that. Therefore, this is the third point that I am making for lordship. That the railways had purported to foreclose it on the basis of a wrong appreciation of facts. 2.54 does not apply to me at all. This also, my lord, I respectfully submit to your lordship. Completely, my lord, takes the bottom out of their impugned letter. Because they are saying on the basis of 2.4, I am cancelling it. And that your lordship will be pleased to see.
Yes.
Your lordship will be pleased to see that at page 186.
No, I've seen. Yes.
So, my lord, this is an instance of non-application of mind by the court. My lord, what is arbitrariness? Arbitrariness, my lord, is lack of reason, lack of non-application of mind, applying the wrong principle, failure to, my lord, consider the facts which are on record, relying upon facts which are not there. This is what arbitrariness is. And, my lord, this arbitrariness is writ large in the government's action. And that is why, my lord, my client challenged this. I submit to your lordship that you are purporting to foreclose a contract which you had given to me without telling me that there had been any remiss on my part.
So
in
then
the
how should
execution of the contract. You are purporting to terminate me at the back end, and you are relying upon a provision which is not applicable. For the purpose of foreclosing, you are relying upon a provision which is not applicable. So what remains of this case? And, my lord, in addition, as I submitted to your lordship, you are not calling upon me, not giving me a hearing. There are judgments, I shall cite before your lordship the judgments, starting from Maneka Gandhi, then Mahinder Singh Gill. Thereafter, up to 2023, my lord, the Supreme Court has repeatedly said, not 2023. In 2025, there's a Dipankar Datta, the latest judgment, that is unreported, I shall cite before your lordship, which says that if an action of the government results in civil consequences, then it is obligatory on the part of the government to give a hearing. And give a hearing, give reason. You should have called upon me. Give reason as to why you have done this, why have you done that. And I could have given reasons, I could have explained the conduct. Not having done so, the action cannot be sustained. That is one point. Second point is, as I submitted to your lordship, that you are saying that I am terminating the contract without making, my lord, the time is the essence of the contract. But if I may just show you, lordship, that judgment first. The judgment of the Supreme Court, 1979. This is, my lord, 1979, and that has been followed, my lord, in a judgment. This is the judgment of Senior Mr. Justice Chandrachud, 1979, two Supreme Court cases, page 70.
Page
70. This is in respect of a building contract. I take your lordship straight to the relevant paragraph.
subsequent thereto, there is another 82 Supreme Court. There is also
On the same point.
on the time being the essence of a contract in relation to a land or
My lord, your lordship is perfectly right. There, my lord, it has been held that in a construction contract, time is the
there can't be.
And therefore, my lord, if you want to make the time the essence of contract, you have to give me this. My lord, this is what it says. Kindly come to para 9. It says that having regard to the aforesaid material on record, particularly the clauses in the agreement pertaining to imposition of penalty and extension of time, it seems to us clear that time, 12 months period, there was time given in that particular contract, was never intended by the parties to be of the essence of the contract. Further, from the correspondence on the record, particularly the letter exhibiting 78, by which the contract was rescinded, it does appear that the stipulation of 12 months period was waived, the contractor having been allowed to do some more work after the expiry of the period, albeit at his risk, by making the rescission effective from 16th August 1956. Then, my lord, can you turn over the page? I am relying upon, my lord, the paragraph from the middle of that page. But this is a paragraph. It's a longish paragraph.
There is no placetum which is assigned here.
Yeah, paragraph 10 is a continuation of paragraph 10.
True.
On the next
I
page,
say that there is no placetum which is assigned.
No.
The whole difficult.
I suppose because it is, my lord, online, it was taken from the online.
Yes.
Supreme Court online. But kindly come to the middle of the page. In our view, after the facts have been stated, monsoon, etc. In our view,
Yes.
the question would not be whether rescission of the contract was unreasonable and therefore unjustified, but whether the rescission of the contract in the circumstances of the case was wrongful and illegal. Kindly see the language. It is not whether it is unreasonable. It is wrongful and illegal. If time was not of the essence of the contract, or if the stipulation as to the time fixed for completion had by reason of waiver ceased to be applicable, then the only course open to the respondent defendant was to fix some time, making it essence. And if within the time so fixed, the appellant plaintiff had failed to complete the work, the respondent defendant could have rescinded the contract. The High Court has taken the view that the contract was rightly rescinded by the respondent defendant because by about July 21, 1956, by later dated Exhibit 74, the appellant plaintiff had done work of the value of rupees 35,000 as against the tender value of rupees 1,07,000. That was one of the ground. That is to say, only 1/3 of the total work had been completed. And therefore, even though time was not of the essence of the contract, the appellant plaintiff in the circumstances could not have completed the work even within the next 3 months. In our view, this approach adopted by the respondent defendant and upheld to the High Court is not correct. Then, kindly my lord, come to the next page. This continuation of this paragraph, my lord. Can you come to, I am not troubling your lordship with the factual position which has been narrated. Can you come to about 15 lines from the bottom of that paragraph on the next page? It will thus appear, your lordship has got that? About 15 lines from the bottom.
Yes.
It will thus appear clear that though time was not of the essence of the contract, the respondent defendant did not fix any further period, making time the essence of the contract. Essence, directing the appellant plaintiff to complete the work within such period.
So according to you, even if in the original agreement there was a timeline which was fixed, but the correspondences or the conduct of the parties would indicate that they have not insisted, rather waived that particular timeline, and they were insisting that you should complete this work and that work, and they permitted you.
Gotcha.
So in that event, once the time limit is waived, then the time is not an essence of the contract. And if you want to make it again or bring it or resurrect it, then you'll have to give the another letter. That is what the spirit of the judgment.
That's what they say. And in fact, in our case, no time was fixed at all. No time was fixed at all. There was no time at anything. Then kindly see, my lord, what it says. It will thus appear clear that though the time was not of the essence of the contract, the respondent defendant did not fix any further period, making time the essence, directing the appellant plaintiff to complete the work within such period. There's not a single letter to that effect. Instead, it rescinded the contract straight away by letter dated 27th August 2053. Such rescission on the part of the respondent defendant was clearly illegal and wrongful, and thereby the respondent defendant committed a breach of contract with the result that there could be no forfeiture of the security. But the entire action was held to be illegal. So I am submitting to your lordship in the facts of this case, quite apart from anything else.
Is a 3-judge bench decision.
Yes, ma'am. And this has been followed in a decision in which I appeared in the Supreme Court and lost. Well, that is reported in 2006 11 Supreme Court cases, page 181. I'm just going to finish one paragraph. In this manner, Mr. Dipankar Gupta appeared against me. I appeared for Bern standard, and I lost that. This was an arbitration, and foreign arbitration, international arbitration. There was an award was passed, a huge amount had been passed on Bern standard. And I think that was one of the reasons why Bern standard went to liquidation. And I tried to resurrect that.
To have been commercially burned.
Yes, commercially burned, completely. And this is there, I had the occasion to argue this matter before Mr. BP Singh and Mr. SB Sinha. Mr. S.B. Sinha left the chat. They will go to that. My lord, kindly come to para 85. The question which further arises for consideration is as to whether the respondents having proceeded on the basis that time was of the essence of the contract, it was bound to issue notice of repudiation of the contract, subject to the reservation as regard the claim of for damages. MII, however, states that it had never raised the contention that the time was of the essence of the contract. Then, my lord, after that, I am not troubling your lordship with regard to the prices, but here, your lordship, on a plain reading of the provisions of section 55, the last sentence in that paragraph. Section 55, the Indian Contract Act. It is evident that the parties did not intend. It is evident as the parties
that the time to be an essence of the contract.
Yes. On the expiry year of the contract became voidable at the instant of the party, but by reason thereof, the parties shall never be deprived of damage. Then, my lord, we may notice that BSCL, that's the one standard, had never pleaded before the arbitrator that the time was of the essence of the contract. In construction contract, generally, time is not of the essence of the contract unless special features exist therefore. No such special feature in the instant case have been brought to our notice. In the instant case also, my lord, there is no such special. Then, my lord, kindly come to next page, paragraph 88. Hinge construction has been quoted, paragraph 7 and 8. And my lord, Hinge construction relied upon Hosbury law of the and paragraph 8, which has been quoted from Hinge construction, even where the parties have expressly provided that time is of the essence of the contract, such a stipulation will have to be read along with other provisions of the contract, and such other provisions may, on construction of the contract, exclude the inference that the completion of the work by a particular date was intended to be fundamental. Therefore, in the Faxport case, time was not of the essence of the contract, and it never was intended to be the essence of the contract. So, my lord, one fine morning you wake up and you slap a notice upon me that I am terminating the contract, that cannot be done. This is the judgment, my lord, where Hinge construction has been referred to. My lord, then I will request your lordship, my lord, to look into the judgments on the violation of the principles of natural justice. I am not going to multiply decision. My lord, kindly come to paragraph 47. Oh, sorry. This is 1978, one Supreme Court cases 405. Well, this is a well-known case, my lord, of Mahinder Singh Gill. Is a constitutional.
Paragraph 8 is more important. Which one? Paragraph 8 or 9?
Well, that is with regard to, my lord, I'm making out a case in the affidavit, but it is not there. I am not troubling your lordship with that. That's paragraph 8, which is very often quoted.
Yes.
Well, at paragraph 47, it is fair to hold that subject to certain necessary limitations, natural justice is now a brooding omnipresence, although varying in the play. Once we understand the soul of the rule as fair play in action, this is Krishna here. Once we understand the soul of the rule as fair play in action, and it is so, we must hold that it extends to both the fields. After all, the administrative power in a democratic setup is not allergic to fairness in action, and the discretionary executive justice cannot degenerate into unilateral injustice. Nor is there ground to be frightened of delay, inconvenience, and expense if natural justice gains access. For fairness itself is flexible, pragmatic, and relative concept, not a rigid, ritualistic, or sophisticated abstraction. It is not a bull in the china shop, nor a bee in one's bonnet. Its essence is good conscience in a given situation, nothing more, but nothing less. The exceptions to the rules of natural justice are a misnomer, or rather are but a shorthand form of expressing the idea that in those exclusionary cases, nothing unfair can be inferred by not affording an opportunity to present or meet a case. Then, my lord, kindly come to para 53. Region Baldwin has been quoted. These are off-quoted, but just as a matter of interest, I remember, my lord, that this, before your lordships joined the, both your lordships joined the profession. This was in 1968. My lord, the case of that Gerau case was being heard by a judges bench in the Calcutta High Court. Well, it was presided over by, if I remember correctly, Justice H.K. Bose, Himanshu Bose, and Madam J.P. Meter and all of them, P.N. Mukherjee, P.N. Mukherjee, they are all there. Well, the most impressive argument that I thought was, I was the junior toddler in the profession, about 2 years before I joined. This argument of Mr. Ashok said, he did not look into any paper. And he argued on the basic principles of, my lord, tort. And he cited, my lord, Region Baldwin, Allen and Flood, Reliance and Fletcher, which we studied, my lord, in our college days. And, my lord, he just off the cuff, my lord, quoted paragraphs. His memory was phenomenal. And, my lord, he quoted paragraphs and requested the learned judges. He just handed up the judgments and requested the learned judges to make a note of it and look it up. He said that your lordship need not waste time on this. And I'm telling your lordship, this is what it is. Your lordship will, my lord, look it up. So Region Baldwin is one such. My lord, then your lordship will kindly come to. I don't want to trouble your lordship with the my lord, this academic discussion on this. Kindly, my lord, paragraph 66. It was argued based on rulings relating to natural justice that unless civil consequences ensue, hearing was not necessary. A civil right being adversely affected is a sine qua non for the invocation of audio alteram partem rule. This submission was supported by the observations of Ram Gopal, Colonel Sinha. Of course, we agree that if only spiritual censure is the penalty, temporal laws may not take cognizance of such consequences, since human laws operate in the material field, although its vitality vicariously depends on its morality. But what is civil consequences? Let us ask ourselves, bypassing verbal booby traps. Civil consequences undoubtedly cover infraction of not merely property or personal rights, but of civil liberties, material deprivations, and non-pecuniary damages. In its comprehensive connotations, everything that affects a citizen in his civil life inflicts civil consequences. And then, my lord, civil right has been defined. Then finally, my lord, I just request your lordship to come to para 73. Para 73. We consider it a valid point to insist on observance of natural justice in the area of administrative decision making, so as to avoid devaluation of this principle by administrators already alarmingly insensitive to the rationale of audio alteram partem. In his lecture on the mission of law, Professor Wade takes the principle that no man should suffer without being given a hearing as a cardinal example of a principle recognized as being indispensable to justice, but which has not yet won complete recognition in the world of administration. The goal of administrative, sporadic, and ex post facto judicial review, the essential mission of the law in this field is to win acceptance by the administrators of the principle that to hear a man before he is penalized is an integral part of the decision-making process. A measure of the importance of resisting the incipient abnegation by the courts of the firm rule that breach of audio alteram partem invalidates is that if it gains ground, the mission of law is doomed to fail to the detriment of all. Our constitutional order pays more than lip service to the rule of reasonable administrative process. Our people are not yet conscious of their rights. Our administrative apparatus has a hard of hearing heritage. Therefore, the creative play of fair play, irksome to some, but good in the long run, must be accepted as a part of our administration. Then Lord Helsham has been quoted. Then kindly come to para 76, the final one. Fair hearing is thus a postulate of decision making, cancelling a poll. Although fair abridgment of the process is permissible, it can be fair without the rule of evidence or form of trial. It cannot be fair if apprising the affected and apprising the representations is absent. The philosophy behind natural justice is, in one sense, participatory justice in the process of democratic rule of law. This has become almost a Bible on natural justice, Maharaj.
But the meaning of the many words have to be as.
My lord?
The meaning of many words have to be found out.
Yes. Some of the words, yes. Some of the words. Well, that is but I believe also that when you listen to it carefully, it's even though the words are big, but for the spirit,
That one can, yes, emotions, the connect you can definitely feel.
Yes, ma'am.
well, I have got a few more decisions to cite, my lord, on this aspect of the matter. And lastly, my lord, with regard to perversity. Because, well, if the court, if it is found that the authority concerned has relied upon the wrong provision for the purpose of, my lord, denuding a person of his civil rights, then, my lord, I respectfully submit to your lordship that's a perversity. And perversity, I shall, if your lordship wants me to continue, I will continue. Bishop, but we can give you one minute, but I lost my handwritten notes. Okay, please. Well, the other judgment, but I would like to cite before your lordship is, my lord, on this aspect of the matter. Kindly give me 1 second.
On a natural justice principle or on a perversity principle? Which one you want to cite? On a natural justice principles or on the perversity principles?
On natural justice, I shall give you, lordship, the reference only.
Yes.
Because the later decisions which are there, perhaps my lord assist your lordship. And lastly, my lord, I will submit to your lordship on the issue of that next has been 2023 6 Supreme Court cases. This is also part of Longley's judgment.
Page.
Well, this is 2026, page 1. Page 1, I only request your lordship to come straight away to para 42.
Oh, this is the Rajesh Agarwal you have given.
Well, then, paragraph 41.
Rajesh Agarwal.
No, this is.
No, you have given my brother something wrong.
That is 23 to Supreme Court.
No, he has given me 23-6 SCC page 1 correctly.
Yes, that.
That is MP.
Now, kindly come to paragraph 41, quoting from the famous Binapani Devi. And it is Binapani Day, not Day.
Binapani they.
Yes, Day.
They.
That is from our board.
My lord, kindly turn over the page. The quotation continues in the next page also. Third line, if there is power to decide and determine to the prejudice of a person, duty to act judicially is implicit in the exercise of such power. If the essentials of justice be ignored and an order to the prejudice of the person is made, the order is a nullity. Then Mohinder Singh in para 44. Then my lord, kindly come to para 46. Para 46 is my lord, the conclusion from all these judgments. There is a consistent pattern of judicial thought that civil consequences entail infractions, not merely of property or personal rights, but also of civil liberties, material deprivations, and non-pecuniary damage. Every order or proceeding which involves civil consequences or adversely affects a citizen should be in accordance with the principles of natural justice. Then, my lord, kindly come to the paragraph 70. Para 70. Well, in the number of that, this is Chandrachud is to almost it's a dictionary of judgments. But here, paragraph 70, I don't have to, your lordship will kindly make a note of it. The Mangila versus State of MP has been quoted here in extenso. And here, it again, my lord, reiterates in no uncertain terms. My lord, this is my lord, Mangila is
The main crux is that to secure the justice or to prevent the miscarriage of justice, and it does not really supplant the law, but actually supplement the law.
Yes, this is what it says. Para 70, and then another para 17, para 80, sorry, para 80. And Tulsiram Patel has been quoted. Audio order imparting has several facets, including the service of a notice to any person against whom a judicial order may be passed, and providing an opportunity to explain the evidence collected. In Tulsiram Patel, this court explained the wide amplitude. And well, this is very important. The rule of natural justice with which we are concerned in these appeals and the writ petitions, namely the audio alteram partem rule, in its fullest amplitude means that a person against whom an order to his prejudice may be passed should be informed of the order, should be
informed allegation and the charges against him.
Well, yes, informed of the allegations and the charges against him. Be given an opportunity of submitting his explanation there, have the right to know the evidence, both oral and documental, by which the matter is that you should give him notice and tell him that these are the facts which are against him. Explain. Give him a sort of show cause. I don't mean exact show cause, but a sort of show cause. And giving it an opportunity to explain. And lastly, my lord, on this aspect of the matter, this 2025, Maharana Pratap Singh. I think this is just a Deepak Dattaja. This is Maharana Pratap Singh versus State of Bihar. 2025 SCC Online, Supreme Court, page 890. This is a division में judgment of just
890.
890. Page up. Okay. Well, may I hand up my copy? Well, I'm sorry, the copy has not been made. We have furnished copies. Well, my copy is not.
No, just read.
I
read
just
the relevant portion.
hand up. There are two short passages. Para 55 is, law is right that while exercising its power under Article 226 and 227 of the Constitution, the High Court does not exercise powers that are available to an appellate court. It is the decision-making process that calls for scrutiny. Be that as it may, the High Courts can rectify errors of law or procedural irregularities, if any, that lead to the manifest miscarriage of justice or breach of the principles of natural justice. Law is also well established that the standards for establishing a guilt in disciplinary proceedings will differ from that. I am not troubling lordship. Standards for establishing guilt in disciplinary proceedings differ from those applicable to criminal proceedings. However, it is equally true that departmental authorities are obliged to provide a fair opportunity to the parties involved. And what constitutes a fair opportunity must be determined based on the facts and circumstances of each case, as has been laid down in State of Mysore. Then para 56. It is well established that any action resulting in penal or adverse consequences must be consistent with the principles of natural justice. To sustain a complaint of natural justice violation based on lack of opportunity or cross-examination, the party alleging the violation must show that prejudice was caused as affirmed by the court in L.K. Tripaঠি's case. These are the two paragraphs.
So this is what the departure that really came, that the natural justice in those era from 1978 or even prior thereto was indispensable. And it was held that it is so deeply ingrained and enrooted in our system that you cannot segregate it. Because it really invites that fairness, the transparency, the avoidance of arbitrariness and everything. Now there was a departure that if by statutory provision one can done away with the principles of natural justice. Now the third principles have come that where violation will not do, there must be a prejudice to be shown. How the paradigm shift or the progress one can have in this regard.
Not really. And this is what it says.